she does a lot of Thank you. That was good. Anything else, Jenny? Okay.
No, Mr. Chair.
Okay, I guess we're going to go to, what would that be, number 5?
No, the consent agenda.
Oh, it's consent agenda. I'm sorry. So we just need to approve the consent. And any questions on the consent agenda? Or anything? Anybody want anything removed? Guess not. Okay, is there a motion to approve the consent agenda?
I move that we accept the consent agenda as outlined.
I need a second.
Second.
Moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Hearing none. Consent agenda is accepted. Thank you. Now we go to board action number 5, Pinyon Ridge Mining LLC, Montrose County. Okay, those of you that intend or are going to testify in regard to this matter, would you please stand and be sworn? Is that it? Please, do you promise to tell the truth?
Yes.
Okay, thank you. You know, one thing, when you do get up, please identify yourself and let us know where you are so that it can be recorded properly. Thank you. Go ahead.
Yeah, I'll just do a brief introduction. Jeff Fugate here on behalf of the division. I'm just going to give kind of a brief introduction, mostly just on process or hearing order. This is a consideration of a second term of temporary cessation. So it's an interesting issue, unique issue. It has very little process outlined in the ACTA rules. And so I've discussed with the parties this morning, agreed to just a hearing order. If it's agreeable to the board, I think this is how we will proceed. Division will provide a brief kind of introduction and overview of this temporary cessation generally that Russ Means and Tony Waldron will provide some of that discussion. Then the division will move into its presentation. They're staffed to the board in this matter, and so they'll be issuing a recommendation to the board. Following division presentation will be the operator presentation. Following that will be the objecting party informs presentation. And the board also received a comment letter from the Western Small Miners Association. Not sure if they plan to discuss or give a prepared statement to the board, but they will be available for question and answer. And then if there's time remaining, rebuttal from any of the parties or questions from the board, parties will be available for that as well. So that process is agreeable to the board. It was agreeable to the parties. So we propose that as the
Any objection to that process from the board? Okay, go ahead, carry on.
Actually, can I ask a question?
Please, go ahead.
Does the board have a copy of the Western Small Miners Association comment letter? Was it in the packet?
Late.
I don't remember seeing it in there.
I think it came in late, didn't it?
I had it. Yeah, I had it in the Google Drive.
Oh, okay.
I have a question too about this Grow Consultants. Does that go with, who does that go with? Does that go with this case?
No, I think that's from the coal item
It is.
in May.
In May?
I believe so. I wasn't present at that hearing, but that sounds.
Exposing my computer literacy. Sorry.
Yeah. So I'll go. I was just going to provide just a little bit of background before we jump into this hearing. So in 2008, the legislature amended our act to is specifically addressing uranium mining and primarily or mostly in situ uranium mining. What that did is required that all uranium mines become designated mining operations. Previously, they had not been determined to be that. Some of them were, but not all of them had to be. That legislation required that they would all be DMOs, what we call designated mining operations. In 2010, we conducted a rulemaking to implement the changes that were in that act. It was a pretty significant rulemaking. We held meetings all over the state, came back and did pass new rules, pretty significant changes, as I said. And then in 2011, we met with the Western Small Miners Association and informed them that we would be sending out a letter indicating that everybody had to submit environmental protection plans to come in compliance with the designated mining operation. At about the same time, we also informed them that this issue of temporary cessation and or intermittent status was going to be evaluated. And what had happened is there are a lot of mines that have been out there for a long time. Many of them have 1977 numbers, which means they were in existence probably at the time the act was passed, some of the first permits that we issued. Uranium mining has been kind of on the downside for a long time. So a lot of those mines went into temporary cessation. 5 years passed, they came back for the second term of temporary cessation, was granted in most instances. And then many of them went into what was sort of a new status, which was intermittent status. Intermittent. And intermittent is typically for sites that conduct mining seasonally. So it might be high elevation sites that can only be accessed in the summertime or something like that. It could be these sites, but there are requirements for doing intermittent. To be in intermittent status, you do have to go out and conduct mining related activities. So in this, like I said, the letter went out in 2011 requiring everybody to get their environmental protection plans, reclaim, and or address this temporary cessation status. At that time, we were in front of the board. We had objections to some folks going into temporary cessation from this intermittent status, but we felt it was appropriate to sort of reset the bar because this thing had been languishing for quite a while, and we felt a fresh start was appropriate, especially given the changes to the law, the designated mining status. And so we sent that letter out in 12, and now it's 17, and these are coming due. But we kind of made it clear that we would not be supportive of another term of temporary cessation at that time to the operators. And I've been conveying that message with some pretty much annual visits to the Western Small Miners meeting, and then also with the Colorado Mining Association, just letting them know that the clock is ticking and this day would be coming. So here we are today. This one has, and every one of these sites has their own unique circumstances, by the way. And this one, you'll see, has some unique circumstances surrounding it. In the term of temporary cessation, the second term must come before the board to get that second extension. And you go into temporary cessation for 5 years for the first term, and then you can have a second 5-year term. And then the law, the rules say that you must go ahead and reclaim if you have not initiated production at that point. And there are some factors that go into it, and it's kind of a complicated rule and a complicated part of the act. I think the rules are sort of poorly written. The act is maybe a little more straightforward about what the intent of this was, but clearly there are downtimes where somebody should be able to take a break and just not have to be out there doing a bunch of stuff at their site. They're just waiting for the market to rebound, perhaps. They still have to pay their annual fees. They still have to do some reporting. But it's a good part of the rule that allows for somebody to take a little time out and not have to begin reclamation. And if you do start reclamation, at the cessation of mining, you have 5 years to complete reclamation in accordance with the act. So those are just some factors, background factors, and I just wanted to bring that up before we jumped in here today, just to sort of refresh the board's memories. Some of you may have not been here at that time, and just give you a little bit of history about what's been going on. So any questions?
I have a question. Did you say that when you met with the miners, that you told them that there'd be increased scrutiny on a second temporary cessation, or on a third one? I guess I didn't understand.
On the second one, yes. So we did, we felt that it was appropriate to allow these sites they were mostly in intermittent status, and that wasn't really the appropriate status, but we felt it was appropriate for them to be allowed to go into temporary cessation at least one more time and kind of reset that bar and restart that clock. That seemed to be like the fair thing to do. And we had a hearing, and that was the consensus of the board at that time, was to go ahead and do that. Now, the board didn't say, well, what they were going to do with the second TC, but it was made clear that we would not be supportive of it as a staff. The staff would not be supportive. Typically, there's kind of some parameters that are laid out there. We'll go out and do an inspection. We'll make sure the financial warranty is up to date. We'll make sure they've been doing maintenance or whatever it is they're doing. And if everything looks fine, we're usually supportive of a second term of temporary cessation. But this has been going on for such a long time that we kind of made it clear. We didn't kind of make it clear. We made it clear that we wanted to see action before a next term of temporary cessation came up. We've been on message with that since 2012. There's no surprise, and I think people could testify to that are here today if they wish to. Been like reminding them, general reminders, and in fact, we just had a meeting at CMA recently, and I indicated that, it's 2017 now. The 5-year period is kind of running. It's up, and we're going to start seeing some of these they either go into production or they'll be back in front of the board requesting that second term. And in almost every instance, I think we're going to be not supportive of that. So I don't want you to prejudge. There are, like I said, each one of these have their own individual facts associated with them, and I think you need to look at these sites individually and make that determination, and it is up to the board to do that. Any questions? Russ, do you have anything to add?
This is Russ Meeks for the division. Tony has mentioned that this is the first series that we'll actually have this one. I think there's one maybe in September, October, and then there's going to be a number of them with a single operator that come due in December and January. So, and like each one of them is different, has their own circumstances, but so this is the first of many. But we knew that coming in. It's been on the horizon for a while, and we've been getting prepared for that. So, but that's the most important thing is it's complicated. The rules aren't really well written out, so in the process. So we're looking for the board for guidance and how we want to move forward on some of this. So, thank you. But with that, we'll turn it over to Dustin.
Dustin Zappa with the division. It's a hearing for the Van 4 shaft, permit number M 1997-032, operated by Pinion Ridge Mining, LLC. This hearing is for consideration of the request by the operator for a second 5-year period of temporary cessation. Just quickly go through a brief summary of the history of the site. June 1st, 1978, a permit was issued for the Thunderbolt mine area, permit number M 1977-287. This included the Van 4 shaft. The last known ore production at the site was in 1989. November 3rd, 1999 is when a permit was issued for the Van 4 shaft, permit number M 1997-032. This area was then released from the Thunderbolt mine area. August 31, 2012, an environmental protection plan was approved by the division through an amendment, AM1. And on October 21st, 2014, Pinion Ridge Mining, the current operator, assumed the permit through an SO process in which they replaced Energy Fuels Resources as the permittee. This was SO3. This is a brief chronology of dates as it relates to the temporary cessation process. March 6, 2014, TC1 was approved with an effective date of June 13, 2012. April 14, 2017, the division sent notice of the TC1 expiration to the operator. On May 30, 2017, the operator submitted a request for the second period of temporary cessation. On June 12, 2017, the division inspected the site in order to document existing conditions. Comments were received regarding the second temporary cessation request. On June 23, 2017, the division received an objection from Inform on behalf of Conservation Colorado, Earthworks, San Juan Citizens Alliance, Sheep Mountain Alliance, and also a letter of support on July 20th, 2017 from the Western Small Miners Association. Division did not receive comments from the notice parties, which included the BLM and the Montrose County Commissioners. As I said, in June 2017, we inspected the site in order to document existing conditions. These next few slides will just show some photos of the site as it is now. Two buildings exist on site, the hoist shed, which is shown in this picture, and a compressor shed, as well as a head frame assembly. The buildings are in somewhat a state of disrepair, broken windows, the interior dilapidated. This is the head frame hoist structure. It is secure with gates. The functionality of it is unclear as it hasn't been used in close to 30 years. This is the interior of the hoist building. The hoist motor is still there. Unclear whether that was functional or not. So you can see the interior of the building is dilapidated. Ceiling material, insulation falling off. Signs of a lot of rodent activity within the buildings. This is a compressor building, tool shed, a similar condition to the hoist shed. It's been mostly cleaned out. The compressor unit in the rear of the photo there. The big pack rat nest on top of the compressor during this inspection. The next three slides, I'll go through the division's recommendation and provide justification for that recommendation. Temporary cessation is granted under CRS 34-32-103, parent 3, so long as production is resumed within 5 years. The last known production at this site was in 1989, approximately 28 years ago. There are no approved plans for resumption of production at the Van 4 mine. And substantial changes to the permit would be necessary before any mining could resume at the site. The existing financial warranty is adequate for the currently approved reclamation plan. Caveat that required financial warranty would likely increase significantly if mining were to resume at the site based on updated mining and reclamation plans. The division does not support the request for a second 5-year temporary cessation period for the following reasons. The operator has failed to demonstrate continued commitment to conduct mining operations as required by Rule 1.13.5, Parent 3, Parent C. Significant changes to the permit would be required prior to any future mining activities. This includes updating the mining and reclamation plans, environmental protection plan, as well as the financial warranty. Staff recommends pursuant to CRS 34, 32, 103, Parent 6, Parent A, Parent 4, and Rule 1.13. The board deny the request for a second temporary cessation period and determine that the mining operation is not in a state of temporary cessation. The board should order Pinyon Ridge to begin implementation of the approved reclamation plan within 180 days of a signed board order and to complete all reclamation within 5 years pursuant to CRS 34, 32, 116, Parent Q. If the board has any questions at this point?
Any questions?
I have one comment about your the authority to grant temporary cessation. I think it's 34, 32, 106A3. Just to correct the record.
Okay.
Say that again, Tom.
Certainly, section 34, 32, 106A3. Or I'm sorry, 103.6A3. So it's in 103.6A3. Yeah. We'll get that corrected. I just want to make sure it's
106.
for the record.
103 or 106?
Let me see. Let me check again. 103.6A3. 103.6A3. Thank you.
Anything further?
Roman numeral 3, we added
Got it.
previous letter.
Okay, where do we go from here?
Close that for us.
The operator.
Yeah.
Okay.
Yeah.
Good morning, members of the board. Patrick Siglin with Pinyon Ridge Mining LLC. Thanks, Dustin, for the presentation, and thank you to the division for explaining the current situation as it stands. In talking with Mr. Fugate prior to this board or this agenda item, I did mention that I brought an addendum to our original request for the second term. It doesn't change the request. It merely sort of rebuts the objection letter that was brought forth by Inform and who they represent. And I guess I can disperse that now if it pleases the board, or we can wait till later. I'm not sure if that's allowable at this point in time.
Okay, if he wants to present any additional documentation, if the objectors and the division have no objection, you can accept it.
Yeah, we'll do that. We'll accept it unless there are objections. Any objections?
No objection for the division. Sounds like it's just rebuttal to.
Right.
Similarly.
Okay. So we go ahead and distribute it if you want.
I guess I don't plan to speak to this submission at this point in time, but if anything comes up, if there's questions or if there are further objections to my statements here, then maybe we can talk about those after Inform testifies. anyway, I guess I'll get started. It's the position of Pinion Ridge Mining LLC that this past month marked the end of the initial term of temporary cessation for the permit. At the time that it was approved, there were no adverse comments submitted, and it was approved by the division with a bond increase. It was the first term ever for the permit, first term ever of temporary cessation, and the requirements were met to change that status from intermittent to temporary cessation. Temporary cessation is defined as those limited periods of non-production as specified in 1.13 of the rules. 1.13 states that notice is required to change status of a permit to temporary cessation. And this request by Pinion Ridge Mining LLC is a request for a second term. So therefore it should be with regards to rule 1.13.5 parent 3. A succession of operators was approved with no stipulations regarding the inability to request a second term of temporary cessation. And therefore, it is the permittee's position that it should be eligible to request a second 5-year term. It is the position of the permittee that it has met the requirements set forth by the rules and the act in requesting a second 5-year term. I'd also like to state that because there was a succession of operators in 2014, Pinion Ridge Mining LLC is in no way connected to any of the former operators of the Van 4. So we are, again, in the first term of temporary cessation. Also, I just wanted to comment that Mr. Waldron stated that there was a notice sent to many of the operators in the Uravan Mineral Belt area regarding these permitted uranium mines and with regards to intermittent status. And in an email exchange that I had with Mr. Russ Means of the division on May 30th, we both agreed that we could not locate a copy of the letter to operators in the file of the Van 4 with regards to this intermittent status and temporary cessation policy change. For now, that's all I have. Thank you.
Any questions? Okay. Thank you.
Morning. Thank you. My name is Jeff Parsons. I'm an attorney. I represent the objectors in this case that include Inform, Conservation Colorado, Earthworks, San Juan Citizens Alliance, and Sheep Mountain Alliance. With me is Jennifer Thurston. She's the executive director of Inform. We've submitted objections in this timely objections in this matter to the second term of temporary cessation. As Mr. Waldron and Mr. Means described, this is an issue that's been going on for a long time. About 5 years ago, we sat before you and had a vigorous discussion about the Mine Land Reclamation Act and the rules and how these mines had sort of slipped through the cracks, so to speak, with regard to having sat without production for so long, yet not having been, through the rule process anyway, put on official temporary cessation status. I think Mr. Waldron's characterization of the sort of feeling of the staff and the board at that time was sort of one of fairness. Despite our objections, that it was fair to give these operators essentially one more chance. What the arguments at that time revolved around were from the operators was that surely in the next 5 years the market will turn around and we will have uranium prices back in a place where these things will be viable again from an economic standpoint, and all we'll need is this first round essentially. And here we are back in essentially the same position with uranium prices even lower than they were at that point, or at least no higher, and we're getting the same essential arguments. I think it's important to realize that, and I think Mr. Means mentioned this, that the rules are not overly, don't provide a huge amount of clarity with respect to temporary cessation, but the statute does. In this case, it's an issue or a condition where the statute maybe provides more clarity than the rules might. And the statute says, after discussing temporary cessation, after discussing life of mine, it's in the life of mine definition. It essentially says that a life of mine, the permit can continue as long as production occurs at the mine. But you can go into temporary cessation for no longer, or for these periods. But it says, I think in very clear terms, in no case shall temporary cessation of production be continued for more than 10 years without terminating the operation and fully complying with the reclamation requirements of this article. So it's not talking about temporary cessation status or referencing the rules. The rules tier off of this, and I think this is the controlling language from the statute. It says, if you're in no case shall temporary cessation of production be continued for more than 10 years. So our position is that this is a settled issue pursuant to the statute, that when a mine fails to produce for 10 years, the statute does not give the latitude for the operator to maintain a permit going forward without being required to fully comply with the reclamation requirements of this article. So I think that sort of where we start from, we look at the statute, and it's pretty clear to me that where a mine is not produced, and in this case, as discussed, it's been close to 30 years since this mine had any sort of production at all, and well beyond that 10-year requirement in the statute. There's always a reference to sort of the purposes of the Mineland Reclamation Act in these discussions, it seems to me. And as I think you probably know, the Act has essentially two motivations that it gives the board. One is to encourage, and what it says in the Act is encourage the orderly production of minerals. And the other is reclamation, to ensure that mined lands are put back into a productive state. And so those are competing, but both have equal, I think, weight. Often the operators cite to the encouraged production part of it, which is valid, but the reclamation part stands in equal position with that. And I think that term in the statute where it talks about orderly production is particularly relevant here. This is a mine that throughout the entire permit, as it was amended in 1997 or sort of reconfigured, it used to be part of another sort of complex in another permit and was sort of separated out, has had no production during that period at all. In the rules, you'll find at 1.13.3, it talks about indications against temporary cessation. And one of those is a permit has been issued, but the mining operation has not commenced. I think we're squarely, so both the statute, I think, speaks directly to this case, as well as the rules are very clear that where no production has occurred for the life of a permit, that we're not talking about a condition of temporary cessation. We're talking about a mine that's in need of reclamation pursuant to the Act. There was a discussion about how a change of operators or a succession of operators ought to factor in here and sort of reset any clocks. And I don't find any support for that in the rules or in the statute. if that were the case, it would seem to me that any of these requirements would be fairly easy to get around if we could simply have a succession of operators and then all of a sudden we get a brand new lease on life, so to speak. I think that would undermine, again, the very clear language in the statute that says, in no case shall this temporary cessation of production continue for more than 10 years. And we're, like I said, well beyond that. This particular shaft hasn't produced in 27 or 28 years. And I think we're at a point where we certainly support the division's recommendation to go forward with reclamation. And this is a site that is not meaningless. As we pointed out in our comments, there's the federal agencies have designated this site as habitat for endangered species. I understand that the Endangered Species Act is not a sort of a factor in temporary cessation, but I think it's important to make it known to the board that we are talking about valuable habitat here, and it ought to be reclaimed and restored to a beneficial purpose. The pictures in our objection sort of lay it out and show there's a picture of the Van Four mine from Google Earth that shows sort of the extent of the disturbance, and it's not insignificant. So I think that's at least important to keep in mind that we are talking about a site that has valuable use for other things other than being unreclaimed mine laying on the landscape. Lastly, from our perspective, the application for the second term of temporary cessation spoke in depth about, or at least spoke to the plans the company has going forward. They talk about a technology called ablation that they would like to implement. But I think as the division pointed out, that is all speculative. There has never been a commercial application of ablation technology. It shows up nowhere in the mine permit file. That is to say, there's never been an application for an amendment or a change to the mining plan to allow for or referencing ablation. The Bureau of Land Management, which owns the land, would also be a permitting and be required to conduct a thorough environmental review of that technology. Nothing's been submitted. Any formal applications have been submitted to the BLM in regard to ablation. And thirdly, under the Nuclear Regulatory Commission's authority implemented by the Colorado Department of Public Health and Environment, ablation is considered a uranium milling technology. So we would have to go through a whole milling license through the Department of Health in order to be legal to operate an ablation technology in the state. What we've seen in the last few years is those sorts of applications are very complicated and complex. The last one was submitted in 2009 for the Pinyon Ridge Mill, which is still at the agency level, having bounced up and down from the courts a bit, but it's still before the agency with no final decision on that mill. So the concept that those are reasonable expectations that all those permits support, or all that technology or that speculative prospect, I would say, of using ablation for these facilities or this facility is a reasonable expectation, I think is flawed. There's been no application to the division, to the BLM or the Department of Health for any of that. And to think that it somehow would spring to life with uranium prices at $20 a pound is, I think, speculative at best. So in support of the division's recommendation, we would say that there has not been a demonstrated commitment at this mine, given the long-term, entire term of the permit of non-production and all of these hurdles that would be necessary to bring it back into production. You heard that even the head frame and the motors aren't even demonstrably workable. So our position, and we would encourage the board certainly to follow the division's recommendation and require this mine be put back into a beneficial use for in a reclaimed state. Certainly want to give Jennifer a chance to address anything that I've missed.
Sure, you covered it pretty well. For the record, I'm Jennifer Thurston from Inform. So I don't have to belabor any points. I want to thank the board for your time. Thank you for reading the very long objection that I filed on behalf of all 5 of our organizations. We're here because we believe very strongly that reclamation is just as important as mining. And, I was before this board 5 years ago with the exact same issues, different set of minds, and you spoke very clearly then as Mr. Waldron recapped a bit ago about how you thought it was fair, and it was fair. And so in 2014, when this particular mine went on to temporary cessation, we didn't feel the need to file an objection at that time. You already spoke, and I'm not in the business of wasting your time. But here we are again, and I feel very strongly it is time to clean up. The site is important for lots of reasons. I've lived most of my life in the San Miguel Dolores watershed and spent a lifetime looking at these mines, wondering what the heck and when is something going to happen here. And even cleaning up just one site, I think, is vitally important to all of us. It is grazing land, it is recreation land, it is mapped habitat for a threatened species. It's important to the Dolores River watershed. And so the organizations that have joined us in this objection are also focused either particularly on the watershed or at the state and national level with the issues of cleaning up abandoned mines. And so I think I don't need to go over what Jeff covered. We do think it's pretty unlikely. There are other uranium mines out there that had bigger hints and whispers of activity, but this one has remained pretty dusty through the years, and it doesn't really hold much promise, I think, for the long term. Even if the uranium market were to come back someday, and possibly it could, it's really unlikely that it's going to happen within the next 5 years. Reclamation of a site really does not pose a permanent and final barrier to actually starting up production again someday in the distant future. But what reclamation does in the meantime is improve everything else. And it's just as important as mining. So I think that's all I have to say. Thank you for your consideration. We appreciate the division's recommendation.
Certainly willing to entertain any questions should the board have any.
Any board questions?
I have one question. Can you talk about the demonstrated effect on the watershed from this site?
Sure. Well, it's this particular mine, happens to be in a highly visible location that is on the prime recreation route for anybody who is going into the Bull Canyon area, which is a pretty active recreation zone. So you have, unfortunately, it's part of a grazing allotment that the BLM has ranked as in the worst condition. So it's degraded habitat overall. There are cattle that are actively grazing on it. There are studies that indicate that grouse and cattle coexist quite well when the range is in good shape. But the bird is further pressured when the range is not in good shape. So any reclamation there is going to be beneficial. It does have, I think the permitted acre is 9.9 acres. Not all of that is disturbed, but a fair amount of it is, including the rather large waste pad and the roads and, the vent site. I pity the operator over the pack rats. They sure are pesky creatures. But, the buildings are also dilapidated. So I think it has an impact from fragmentation of the habitat, from, exposed waste rock that is dispersing particles. Fortunately, it's a flat site, but there is runoff, and, the company did have to do some improvements to the stormwater management system over the last few years, and it's highly visually impacted for recreations.
You said unfortunately there's a grazing lease. What did you mean by that?
I said, fortunately, there's a grazing lease.
I thought you said unfortunately.
Oh, no. There is a grazing lease, and so I think it's important that the range be in good health in order for the cows to have a good life, but also so that everything can work in balance with each other, right? These are public lands, so multiple uses are important, and everybody needs to be protected. The cows do kind of walk over the impacted areas with the waste rock piles. I haven't come across any studies that specifically look at the impacts of that, but I think it raises questions in the minds of lay people about what the potential impacts could be. Obviously, it's a good thing that there's grazing on public lands, and it's important for the range to be healthy. So again, I don't have any objections to mining. Mining is, we all agree, is a dirty business while it's going on. What we really care about is that the reclamation be good. And you can accept those kinds of disturbances when there's mining, but there's not mining at most of these mines.
So I misunderstood you to say, what I thought you were saying was that the grazing was having an impact on the grouse habitat in this particular case.
Well, when the recent studies that I've looked at.
Well, I'm talking about this specific case.
Yes.
Were you not being specific about
I guess
this?
I was. Perhaps I was unclear, and I apologize. There have been studies that looked at how cattle and grouse can coexist in the same area and do very well when the range is healthy. When the range is not so healthy, then the cattle can impact the grouse, and there are more disturbances, and it's harder to recover that species.
Well, is this range,
Yes.
in your opinion, healthy or unhealthy?
It is unhealthy, and in fact, the BLM
Just where the
has
mine
said
site
so.
is, or the
Yes.
whole lease?
The entire allotment. Sorry. The entire allotment is listed as unhealthy by the BLM.
Do you know why they continue the lease? What do they do about that? I guess my ultimate concern is if you reclaim it and it's under the grazing lease and it's already been overgrazed, how is the reclamation going to work?
Oh, well, these are probably issues we'd need to take up with BLM. They do reviews of grazing allotments about every 10 years under the NEPA, National Environmental Policy Act. And so they will change the terms of the leases if there's ways that they can improve the range health overall. So, they may reduce the number of days that cattle are allowed to graze there, for example. They could restrict areas if they wanted to.
This is Jeff Parsons. I think the point is that having unreclaimed waste rock further impacting that range certainly does no favors.
I'd just like to say every little bit helps. We have to do all of this piece by piece.
Okay, anything additional?
Mr. Chairman?
Yes.
I just have one question I want to ask Mr. Parsons. You mentioned something about if the site was not, never initiated production or some language. I know it's in the rules. Is it also in the act? And if it is, can you just point me to where that is?
I don't think it's in the act, but it is in Rule 113, 13.32. And it discusses indications against temporary cessation where where a permit has been issued, but the mining operation has not commenced. In the act, I think the most important language is sort of this: in no case shall temporary cessation of production be continued more than 10 years. Yeah. Rome, 6A, Roman 3 of 34, 32. Thank you.
Anything further? Is there anybody here from Western Small Miners Association? You want to be considered as a party? You want to be considered as party?
That was our request.
Okay.
Any objection from the division?
No objection.
Any objection from the operator? Mr. Siglin? Mr. Parsons, any objection?
No objection.
Thank you.
Identify yourself.
My name is Paul Salagi. I'm a board member with the Western Small Miners Association. I've been here for these discussions in 2008 and 2011 in the rulemaking with the division at our annual stakeholders meetings. And I get to come to these meetings because I live in Boulder. You know, that's the number one. First, I'd like to apologize. We submitted our letter on July the 20th. It was our understanding that to be timely, it had to be submitted by July the 21st. We thought we were timely. And if we weren't, we weren't. But because you didn't have a chance to see that, I would like to take a few minutes of your time to go over what I think are some key points in this letter and this issue, and also to briefly respond to some comments that were made beforehand, if that would be okay. And I will be brief.
Proceed.
Thank you. Our organization has been fully supportive of the act and these rules. And we've worked very, very hard these past few years to do that. I would completely agree with Mr. Waldron and his comments in 2011 at our meeting to reset the bar. I will tell you our impression at the Western Small Miners was one that was very different, and I think one that's pertinent to your evaluation. In 2011 was the very first time any mines went into temporary cessation. We believe the rules are quite clear that no mine can be in temporary cessation for more than 10 years. But to quote Mr. Waldron, resetting the bar meant temporary cessation started in 2011. The letter that we sent you says very clearly that we believe, and it's our position, that if people are in compliance with the act, if they've met all the rules and regulations, if they've responded to every comment made by the division, that the rules allow for the granting of a second temporary cessation. I will completely agree with Mr. Waldron that the bar was going to be higher, that you would have to show that you were in compliance with the act. And as I think as the division cited in their presentation, their comment was that the applicant had not demonstrated continued commitment to mining operations. I would tell you that the Western Small Miners position is that if people are complying with the act, they're demonstrating commitment. If they're doing everything the state requires, that's demonstrating commitment. We also understand that the board has great discretion in its decision here. But the rules are very clear. There's really only that one comment that's at issue here. Is the operator demonstrating commitment? We would request that you view each of these based on the conditions of any mine in question that's applying for temporary cessation. We'd ask you to, recall the intent of these rules, which you state in, or intent of the act, which you repeat in the rules, that it's to promote both the mining industry and the reclamation of these projects. So I originally came here to answer any questions that you might have on our letter. And you'll see in our letter, in addition to the discussion of the rules, we talk about what the U.S. Energy Information projects for the use of uranium for clean, carbon-free, 24/7 electrical energy going out to 2040. There's a chart in there that talks about where the United States currently gets its uranium, a little pie chart. Now, I will tell you that 50% of that is committed under Russian control, and a number of it is committed to China and India through contracts. And the United States had a Senate hearing this past week to discuss that very issue. I would also encourage you to consider that we're not just talking about uranium here. We're talking about vanadium. It's a base product for metals. It's something that has great promise for renewable energy storage at a grid level and a facility level. And I would also tell you that in the past few years, and including one that I was a part of, there have been many new minerals described out of the Uravan mineral belt. There's only 4,000 that have been known to mankind in our history. We have dozens that have been discovered recently. And with that, I'd like to thank you for your time and answer any questions that you might have.
Questions? Okay. Thank you very much.
Thank you.
Jeff, again, on behalf of the division, we don't have any rebuttal statements. I'm not sure if the other parties may have rebuttal, but we did want to make staff available once again to board if they have any questions after hearing other party presentations.
I have a question. Are we saying that this 5-year temporary cessation is different for uranium mines than it is for construction materials mines? In other words, are we saying because of the discussion that happened at the time these new rules were put in, it's different than if it was a construction materials county pit, for example?
This is Russ Means for the division. Actually, when we started this process with temporary cessation, uranium mines triggered the conversation on temporary cessation as a total. At that point, we sent out letters to all hard rock mines, and then later on, we followed that up with a letter to all construction materials mines relating to temporary cessation and also the requirements of intermittent operation, which clearly states within the act and the rules that they have to be active annually in production. So to answer your question, it's not just about uranium mines. It's all the way across the board. We addressed it with every permittee that we had. We sent a letter in and said, temporary cessation is something we reviewed, and we went through at a staff level. We went through and looked at permits. We're still working our way through on a few of the intermittent operation ones, but on the construction side of it, but we have looked at all of that. But it is all inclusive, not just uranium.
Well, my understanding is the way it has been basically applied to construction materials is if you could prove that there were reserves there, even the second 5-year temporary cessation was almost automatic. You had to come to the board, but you had to, in effect, be able to prove there was a reserve there.
Correct. Yeah, and that's the same thing with any hard rock mining. Is if do you want to go into a second set of temporary cessation, if you will, you have to still have reserves available, ores available, construction materials, aggregates, or whatever available. That's part of that process of the TC is demonstrating that you have that.
But as I understand it, in this case, you're recommending against the extension because of this agreement that was made or this warning that was given in particular to uranium mines that they were only going to get one 5-year extension, irregardless of proving reserve and that sort of thing.
Our position at that time, and Tony can probably clarify that a little bit as well, if I'm not correct, is that because back in, well, I'm going to get way back a little bit on this, but back in 1990, the processes and stuff that were involved for technical revisions, anything, was the board approved it. So if we had a TR, instead of us doing it at a staff level, the board approved everything. The uranium mine industry was in a boom and bust at that time, and they had several of these mines that actually were up against their second TC. And the board at that time approved switching them to an intermittent operation for a couple of the sites, and then the staff at that time took that as the guidance to put the rest of these into an intermittent status opportunity. In that time frame, for whatever reasons, and that those mine sites are set idle under an intermittent operation status, when in fact it should have been in TC probably. None of us were here, so we can't say exactly what the board's thinking was then and how the staff moved forward on that. So it was not fair to come in 2011, 2012, and tell the operators that you've already had all of yours, you've exhausted it, when in fact the board back in 1990 made the decision that affected them. That's why we drew a line in the sand and said, okay, we can't fix the past, but moving forward, here's what we got. You, in essence, had a lot of time, but we're not going to penalize you necessarily for that particular part of it. But just be aware that when you get your first TC, we're not going to be in front of the board supporting a second one because of the exorbitant amount of time that expired in the past.
So my question is, what I think you're saying is specifically that you're going to treat the second TC differently for uranium mines than you are construction material mines, because in general, the industry was in intermittent status, which is not the case with some other part of the industry.
And I'll try to address that, and then if Tony or Russ have some information supplement. It is almost two different conversations because it is two different acts, different standards. But really the focus is on the site-specific facts, particularly for the uranium sites or the sites that Russ has indicated will be coming before the board here in the next 6 to 8 months. They have been in some form of inactive or intermittent status for a large percentage of their life of mine, which is not generally the case for the construction materials pits that received the letter from the division indicating intermittent status is no longer an acceptable status for a particular operation. The statutory language is the same in both acts. It still addresses production. It addresses resumption of operations. Unfortunately, I don't have my construction materials rules to know if the rules are different. But the analysis will still essentially be the same, and really it kind of focuses on that 1.13 language of demonstrate a continued commitment to conduct a mining operation. That's where you get into the fact-specific analysis of a particular operation. Specific to this one, as the division is discussed in its presentation, simply just stating you intended to mine in the future is not enough when the site conditions indicate otherwise and the permit itself indicates otherwise. Moving forward, whether it's a hard rock site or uranium site or a construction site, if their facts indicate otherwise, if they can prove that they've got a demonstrated commitment to mine in the future, that is something that the division will take into consideration when it issues its recommendations on a second term of TC. Many of the discussions that Tony had with representative groups was, if these sites continue to maintain the status quo and make no changes, it's very difficult for the division to change its position on supporting additional temporary cessation. So with all that going on, it's hard to predict if a similar approach will be taken on a construction site that is in some form of temporary cessation in second term.
But if I understood what Mr. Means said, is the same logic will apply to construction materials, because there was a letter sent to everybody saying we're not, in effect, the staff's not going to recommend a second temporary cessation without some kind of additional proof.
If I could address that for a second, that's not correct. So, and I wanted to correct something that Paul said. He said many of these mines had not been in TC, but in fact, a lot of these mines have been in TC. They went through 2 terms of TC before they were put into intermittent status. Okay. Some of them haven't though, and each one of these sites is going to have their own individual review. And in fact, this one today was never in TC, okay, because it was permitted late. It went right into intermittent status. The previous operator may have been in TC. We're not able to determine that. This was kind of split off in 97, I believe. So a lot of these 77 mines went through TC1, TC2, and then it was like 1990, and that's when this determination was made to put them in intermittent status. That languished for a long time. Now, some of those mines came out of that intermittent status, or they went into production. The Sunday Group, for instance, some of these sites were permitted more recently. Whirlwind, or one of them was in 2013, I think, was permitted. So those are going to be evaluated a little bit differently, but the ones, the vast majority of these older sites have been through their cycle of TC and have been in this intermittent status. And really, we felt that was inappropriate, but we also did address every site in the state by sending out a letter to all the hard rock sites at the same time, and then followed up with the construction sites. And you'll notice on our consent agenda, we get 1 or so of these TCs about every month. We've also changed our process a little bit to make this a little more in the daylight. But no, I think we'd be supportive of many operations, most operations, in fact, coming for a second term of TC if they can demonstrate they have reserves left. They've been in compliance, as Paul said, with most of these sites. They intend to resume mining, and we would be supportive, and we typically are supportive. I mean, the law is pretty clear, and even Mr. Parsons stated it's 10 years of time. For no longer than 10 years, then you need to start reclaiming. So I think that's where we are. But these are kind of unique animals here, and we're going to have to look at each one of them individually and look at the facts surrounding each one of them individually, I think. And this one's a little bit different. It did not have a TC that we can determine. That's true, but it was in this intermittent status, which was sort of a de facto TC. And then we reset the bar on all of those at the same time. So I hope that helps to clear it up a little bit. Maybe not.
Yeah. I can think of a couple of sites and stuff that we've been at recently, actually, that are in TC, that if they come back for a second one, they're not uranium, but if they come back for a second one, the division will not support it because of the lack of upkeep and other things and stuff to comply with the act and the rules. So it's not just uranium. I mean, each one of these sites is different. So I would not say definitively that this is a uranium issue or that we wouldn't do that at construction material. Each site is individual. We're going to have to take a look at the record, at the history of the site, and that's what we have to do to evaluate it before we can come to you with a recommendation. So each one of them is going to be different. So, and you may have 2 gravel sites, but they may have totally different set of circumstances in history. Where one we would say, yeah, that's fine, and where another one we would say, no, we don't think that they've demonstrated that commitment to move forward.
I have a little problem how you demonstrate a pit in southeast Colorado that hasn't been mined for 5 years, and how you've demonstrated you still intend to mine it. But I like the idea of individual cases, but in this case, you're telling me that this individual case was not one of those that was in temporary cessation.
Not in the.
There isn't any record of it. Let me put it that way. Of it ever being.
It was under the Thunderbolt, and the records for the Thunderbolt only go back so far. They don't go back that far, so we can't determine that it is or was not. This was carved out in 1997. given to, and then the rest of the Thunderbolt group was actually released in 2001, 2002. So we're looking at the records, so I can't definitively say yes or no. All we know is for the fact and stuff that it was in this intermittent operation status that was given in that area for these particular types of mines. When we reviewed the intermittent operation, had those discussions, it says very specifically that they're supposed to be in production annually for 180 days or less. And in our determinations and reviews of that, none of these sites were in production annually. They were doing other maintenance things, minimal work and stuff, and that to keep the sites in
That's the part of the discussion before that I remember.
Yes. Yeah, and that so part of that, yeah. So you get into the intermittent operation part of it. A lot of these sites in that we're doing some weed control, some minimum stormwater control things and stuff, but they were not in production annually. But that's whole another field of weeds.
I don't have any more questions.
That's it.
Welcome to the world.
Anything further from the
Thank you.
permitting what you want to rebut or you want to?
Patrick Siglin, Pinion Ridge Mining LLC. With regards to the Act 1036A3 and the mention of temporary cessation of production, it is our position that that reference is in fact part of the definition of temporary cessation, which again is described in the rules in 1.13. There was also reference to 1.13.3, but again, we are requesting a second term, which is 1.13.5, not a first term. It is our position that we are in a first term. We're requesting a second term. It is our position that this is, again, the first term this mine has ever been in temporary cessation. We successfully got a succession of operators, 2014, with no stipulation or otherwise other type of notice stating that a second term would not be allowable. Regarding sage grouse habitat, it has always been the permittee's willingness or position to work with the BLM, the administrator of the land, with regards to any requirements that relate to habitats. This specific habitat is currently under review and is not final. Furthermore, the BLM administers the land, and this particular property is held by the permittee via 80 mining claims. The property is on locatable minerals, and in the BLM's resource management plan specific to the Gunnison sage grouse, which is currently in draft form, there are no suggestions for withdrawal of locatable mineral property from this area that the permit is within. As far as demonstrating that we have a commitment to continue mining, Pinion Ridge Mining LLC is part of a public company. In the way that a public company such as Western Uranium Corporation raises funds to continue operations is that we have to sort of sell our assets. The Van 4 shaft permit is one of the company's assets. If we lose the asset or a portion of the value of that asset, it will become more difficult to sell to investors, the prospect that our company can go into production. I have clearly outlined in my initial request our plans to try to resume mining, and those are contingent on a few factors coming to light. Development rock has been characterized as part of the environmental protection plan, which was required because the permit was put into designated mining operation status. And in that environmental protection plan, it specifically states that grazing was addressed and found to be unlikely to have health effects on deer, mouse, cottontail, bighorn sheep, white-tailed deer, mule deer, elk, cattle, and sheep due to both generally low level of metals as well as unvegetated nature of the development piles and hence the diminished possibility of grazing. Regarding reserves, the reporting of, this is number 9 in the addendum that I submitted this morning. The reporting of proven resource values relating to permittee landholdings in Western Uranium Corporation Stock Exchange disclosures is governed by specific legal and exchange requirements. Non-reporting does not necessarily negate the existence of additional resource which may be demonstrated but not proven in accordance with legal and exchange requirements by historic data. In former operation, in the case of the permit and adjacent permittee landholdings, historic drill logs and maps from former operators identify an estimated uranium and vanadium resource adjacent to and east of the current extent of the underground mine workings, which are a part of the company's mining claims. It is the position of the permittee that no part of either the rules or act of the permit the board to base a decision with regards to a second 5-year term of temporary cessation on whether or not there are reserves remaining on the permit. That seems to be clearly defined as the rules required for a first term. I think that's all I have. Thank you.
I have a question. Do you know who submitted the financial information on Western Uranium Corporation? Did you do that or did the objectors? Did you submit financial information on Western Uranium Corporation?
To the board?
Yes.
No, Opinion Ridge Mining LLC did not submit.
Okay. All right. I'm going to ask a question. It may not be fair, but I assume the objectors are the one that gave us this information. But in looking through it, it looks like at this point, the last 2 years, Western Uranium has not mined anything.
That is correct.
Okay.
Just another comment, please. The uranium market is, in fact, at a very low spot price right now, and it is not feasible or economic to mine uranium or vanadium at any of our assets or properties.
Okay.
Any other questions, Bob?
Thanks for being here. I just want to, just a couple of factual questions. When did production last occur at the Van 4? I didn't see there was an assertion in the objector's letter, and I'm just trying to figure out if it's contested.
I don't contest that. We have no relationship to the former operators that would have produced. I think it was, if they said it was 89 or 90, that might be correct. The permit was, I think the operator that prepared the environmental protection plan, because of those new rules, assumed that the actions they were taking were considered to be in the active status realm of the mine. And I think a lot of the uranium mines in the area thought that was the case. You know, environmental protection plans required field surveys, sampling, additional disturbance on the site in the permit area. And that last occurred in 2012. But actual pulling ore out of the mine, I can't specify exactly when that happened.
Okay. And then the second question is with regard to ablation. Has the company sought permits for the use of ablation technology in Colorado or elsewhere?
Yes. Western Uranium Corporation went through a determination process with the Colorado Department of Public Health and Environment that began 2 years ago now and sort of wrapped up last December, December 2016, with a determination by the state that we would be required to undertake a milling license process to use that technology. We are still in consultation with company counsel and may or may not decide to go down the route of trying to get that license under the milling determination that was stated by the state. Yeah.
Okay, that's great. Thank you.
Anything additional? Not yet. I'll get to you. Anything more? Are you?
I have no more. Thank you.
Thank you. Objector?
Jeff Parsons again for the objectors. Very, very briefly, there's some discussion about Rule 1.13 and what provisions might apply to a first term versus a second term of temporary cessation. And we certainly take issue with the operator's characterization that some of these requirements apply to a first term, but not a second term. If you look at the rules, 1.13.1 says general provisions, and that specifically requires a demonstration of mineral reserves are shown by the operator to remain in the mining operation. So there's an explicit requirement for all temporary cessation, regardless, that mineral reserves be shown by the operator to remain in the operation. And the application material contains no such demonstration. Then the rules 1.13.2 and 1.13.3 are indications of temporary cessation and indications against temporary cessation. Again, I think very clear from the context, apply to all, whether a first or second. And again, in that indication of against temporary cessation is where a permit's been issued, but the mining operation has not commenced. Then you get to a provision about temporary cessation for a portion of the mining operation, and then the provision that Mr. Siglin referred to, 1.13.5, which is noticed by the operator. So that's essentially where you get into the nuts and bolts of how an operator submits something. But I don't think in any way it can be interpreted to exclude the general provisions or the indications of and against temporary cessation that we cited. I don't think there's a basis to say that somehow for a first term of temporary cessation, you need to show these things, and these indications apply, but a second term, it doesn't. In fact, I think that wouldn't make sense for the rules because the second term has to come to the board, whereas the first term can be approved by the division action. So it's would certainly make sense that all of these provisions certainly apply to the second term of temporary cessation. And that was referenced in the new submittal by the operator, that their position is that no part of the rules of the Act permit the board to base a decision on whether there are reserves remaining in the permit. I think that's just flatly contradicted by the rules. And in terms of, lastly, in terms of submitting applications for ablation, I have to just sort of explain a little bit what my understanding is there have been no applications made for a permit for ablation in Colorado. What the company did do was requested a determination from the Department of Health as to what permit process would apply should they propose a permit. That was somewhat hotly contested. As you might expect, they were saying that they did not need to go through the sort of permit process, licensing process from the Department of Health, and we were asserting in that process that it was obvious that they did. The result of that was a confirmation that yes, indeed, they do need to go through that process, and nothing has been submitted to further that end at this time. So I just, in terms of how the rules affect and what applies and what doesn't, I think that's important to clarify. And that's all I have. Thank you.
Any questions? Okay, thank you. I saw, did you want to make one more statement from Western Small Miners Association?
Paul Szilagyi, Western Small Miners again. Tony is right. I did not mean to insinuate that all these temporary cessation cases were the same. I think, in fact, to quote Tony again, they're all very unique. And I would say that when you go back to 2011 and there's a meeting to reset the bar, I would tell you our opinion would be it would make it a lot easier if everything in the past was left in the past. The board had to deal with the facts and matters of today, and it could be applied uniformly across all permit holders, again, assuming they were in compliance with Colorado law and Colorado rules. So my apologies. That's my mistake to insinuate it was something other than that. I certainly didn't intend to, but these are all individually unique cases, and I would completely agree. Thank you.
Sir, could you spell your last name for me?
S as in Sam, Z as in zebra, Ilagyi.
Thank you very much.
And it's Hungarian.
I'm glad I asked, because that is not how I asked.
Sure. Well, let's see, how do we want to handle this? Anything further from staff? Operator, if you have anything further you'd like to say, we want to make sure you have the opportunity to go last if there's anything further you want to add to the equation.
I better just come forward and see if I can keep anything on the mail.
Patrick Siglin, Pinion Ridge Mining, LLC. I guess I have nothing further. Thank you.
Okay. Thank you very much. What I'd like to do with the board's permission is I'm going to close testimony, and depending on what you want to do, if you want to go ahead and finish, our duty here, or you want to take a short break, then we can do it right after the break. Closed at this point.
I just didn't finish.
Okay. Anybody else? Fine. Go ahead. Does anybody want to express their thoughts and comments regarding the issue?
I guess I'll go. I guess one thing that in my opinion, this is a pretty simple issue that we're looking at. I tell you what I think it's not. It's not a debate about the mining process. It's not a debate about potential mining impacts. That's already been addressed. It's not a debate about the condition of the equipment or whether there are pack rats found in the building. I think it's a debate about changing the rules of the game. And I agree that the TC should have been invoked long before it was. But the fact of the matter, it wasn't. It was invoked 5 years ago. And I think to only give 5 years instead of 10 years for TC is pretty arbitrary. I think this company has a big investment that would be lost. And I don't think it's up to the board to decide how bright their future is or isn't. I don't think we're in a position to make that call. They have an environmental protection plan in place. And I don't think in the next 5 years, it's going to make a lot of difference. whether we shut them down or not at this point. And they have a permit in place. It's in good standing. And my opinion is they should be given another 5 years of TC.
Anything else? Bob?
Thank you. And I thought that was well put. As I look through it, I recognize that staff went out and talked about resetting the bar. I'm a little concerned that I don't know that we have the discretion to do that. The statute speaks to temporary cessation as a factual status, not a legal status. And I'm trying to work through this. So, you know, the law was in place. We could have, the staff could have possibly been vulnerable to a challenge in the past for not enforcing it, I guess is my point. And so while I recognize we've been trying to do what is fair by putting companies on notice of our intent to enforce a law that's been on the books, I don't know that we have the discretion to do that. The rules talk about temporary cessation as a legal status. These are 5-year periods. They can be granted once. They can be renewed. The words are capitalized in the rules and the statute. They're not. So it's to me, again, as I look at it, it's more of a factual status. I think the purpose of that provision is not to take away a permit. It's to effectuate the legislature's intent that these mines operate or be reclaimed. And that's the effect of a board order supporting staff here, in my view. And that is a direction to mine or reclaim your site. And here, you know, again, the ability to be in temporary cessation for 10 years, there's undisputed evidence that it's been more than 10 years since they have operated. And so, again, that's what I'm trying to work through is, do they meet the standard? Do they continue to meet the standard for temporary cessation? Even if we were to sort of ignore the 20 plus years of history here. And so the reason I was asking about ablation and sort of where that stands is I think that goes to the continued commitment to conduct mining within 5 years. And I haven't seen sort of the forward, I haven't seen much happen in the last 5 years. And so I'm again, just on these facts, trying to work through whether or not there's a continued commitment. So I look forward to other views too.
I guess I missed all the discussion 5 years ago on setting the bar and that the next temporary cessation would be difficult to achieve. The most of the discussion I remember was on the basis of what's production, because a lot of the argument was what was happening on the site that would allow them to go ahead and get a temporary cessation ruling. And so I guess I do have concerns about raising the bar on what temporary cessation is going to be allowed, because in any end, whether it's hard rock or uranium or construction materials, on the basis of letters were sent. Because I think the intent, in my case in construction materials, the intent was the market changes and moves geographically and economically as far as the value of the reserve. And so what that allowed was the operator to have it permitted, and he still is subject to inspection. He still has to keep the bond adequate and that sort of thing. And so I'm a little concerned about making a ruling of stiffening the requirement for temporary cessation, because we as a division or as a board didn't do our job back in the 1990s. I agree wholeheartedly with Forrest. I just don't believe that we get into a situation where we start making economic judgments as to whether a particular mineral or construction material or anything else is going to be viable in the next 5 years. I don't think we have that ability. I think we open up. So the economics, I think, of ablation or anything other than Bob's reference that indicates they really aren't serious about mining. I'm concerned that I know more about their financial condition than maybe I should have because I read through their financial statements. And my main concern is that what the staff has said, and that is the bond is adequate. That 5 years from now, it'll be okay. And as long as we're comfortable with that, then I was in a position to take a look at granting temporary cessation. And to me, that's the key fact here is the bond adequate? And if we give them 5 more years, and based on the exposure, as I understand, it's less than 9 acres. So that's kind of where I was coming from. I share with Bob, I'm torn as to the right decision for those reasons.
I agree. I think it's difficult to estimate or guess what the market will do in a certain period of time. So if you take away the opportunity for them to recoup their resources right now, going to the future, that's very challenging and does kind of give you the economic power over a company that maybe we should not have. That said, I'm struggling with the demonstrated efforts to continue mining as well. It doesn't sound like there's been much work done at the site in terms of general upkeep. I mean, if you're saying that maybe motors don't even work, that's a definite challenge to getting started again and again with this ablation case, where there really hasn't been a lot of effort past working with CDPHE to actually apply for these permits and get going again. That also doesn't show a lot of demonstrated efforts on my part. And I also think there's an opportunity for a middle ground. And maybe that's something that temporary cessation hasn't allowed for in the past, but in this case it really could, because you have, just in terms of habitat protection, you have a grazing opportunity. You have an opportunity to improve your grazing in this area. What would improved grazing standards do for this overall habitat that could then positively impact sage-grouse habitat, as well as sort of help with the overall reclamation of the site during this next 5-year period. And there's some other temporary stopgaps that they could take, that the operator could take in terms of maintaining the site. Something as simple as putting native soil on top of a waste rock pile so that you have a little bit of contamination control there as well. And that might meet the middle ground between the environmental concerns and the habitat concerns, as well as the opportunity to mine in that area in the future.
I guess my thoughts are, kind of looking at our board, it's been our duty. This is the history of mining in Colorado goes back to the days before we were Colorado. And our job kind of is to make things work in the mining industry. And so long as it doesn't, hurt the surrounding properties. And I agree. I don't think anything's happened. And I think they're just sitting there waiting and hoping that the market's going to change. I don't think there's any question about that. That may or may not be bad, but demonstrated today, no demonstration came from me that the site right now is really hurting, the exterior properties. So and it is tough, it's tough for me to put somebody in a position when we've kind of changed the rules a little bit. In other words, we haven't really demonstrated legally that they had a first temporary cessation. So I guess I'd have to lean, although I would sure like to see more activity, and I don't know what uranium's going to be. That's what Colorado's been all about. So I guess I would lean toward, force thoughts, but not as harshly as you did. I'm concerned about the property over there, and I'm concerned about what's happening, and I'm concerned about the no activity, but I feel uncomfortable at this point in time to not give them a second 5 years. Because we haven't demonstrated, they just fell into this loophole, and I appreciate the staff because we've got to catch up on these things so that we aren't in this position again. And so to bring us to date on these things is important. But I've just got a problem. I don't feel real comfortable about that. But I do. Nothing's happening over there. I mean, that's pretty clear. So.
Yeah.
So I don't know. Anybody want to throw out a motion?
I'd like to make two other points. First of all, my first reaction was the succession of operator has no relevance as to the timing of the succession or any of that. But yet, after finding out that all of this information about the second temporary cessation was going to be tougher than the first, or may not be granted at all, came before the SO. I still don't think it's relevant, but I think it's interesting in this case. The other thing is that in the staff's recommendation, they said the operator has failed to demonstrate continued commitment to conduct mining operations as required by Rule 1.13.5(3)6. Significant changes to the permit would be required prior to any future mining activities. This includes updating the mining and reclamation plans, EPP, and financial warranties. I'm not sure how that gets done during the temporary cessation. I'm not sure that in any case, if you grant us a temporary cessation, they want to come back and start mining, do they have to go through the permitting process again as far as their reclamation plan and how they're going to produce and that sort of thing? Because I thought temporary cessation was you have a mining plan in place, you stop it, you don't have to reclaim it. The market comes back, you go back and mine it the way your permit was written and approved. And so I'm a little concerned about this staff recommendation that says one of the reasons we should not support this TC is because their permit isn't adequate. It seems to me like if the permit isn't adequate, that ought to be pursued.
All right.
So that's a good point, and I was trying to think that through too, and that's why I asked the questions about ablation, because there's a lot of things I'm not. Among them is I'm not an economist, or I don't know what it would take for the company to go forward financially. But I saw in their submittal that the price is half of what it was 5 years ago. The use of ablation could reduce that delta because it reduces the costs by about a quarter. And so their continued commitment, this is in that section of their letter, was we're committed because we're going to use this technology that reduces our costs. I think what the staff is saying is that if they were so committed, they would be seeking approval to use that technology. And here they just haven't. They did seek a determination from CDPHE as to milling, and I recognize, and respect that they might accept that outcome. They might challenge it, and that's fine. But again, when I look at the regulatory standard about a continued commitment, I don't think they've met the mark there, because what they're saying here is in their submittal is, boy, there's just no way we could do it at today's price. The only way we could do it is if we were to be able to cut our costs. Yet they're taking no steps to being able to do that. And so again, I'm uncomfortable with the second period of TC, both because of the statutory language. They haven't produced for over 20 years, and the statute talks about temporary, and to me, temporary isn't 20 years. It's 5, and it's maybe 10 if, you know, if there are circumstances and they show a commitment. And I don't think that they've met those marks. So again, that you're right. It's within our control whether or not they have to make changes to their permit, and that shouldn't be the basis for us denying the TC. But the fact that they haven't done so, or they haven't sought to do so, is to me evidence that they're not that committed. Finally, and I, again, staff changes, administrations change, approaches change. I don't think we've changed the rules, but we are changing how we are going to enforce them. I think the rules have been, you know, the statute as to temporary cessation is unchanged. That's not a new provision. So that's been the rule. The question is whether or not we've sought to enforce it. And on that, shame on us. But again, I feel sort of compelled to say that, you know, we're not changing the rules here. We're changing how we are going to enforce them. Is my view of the staff recommendation. And again, I, based on the facts here, would go with their recommendation.
I would just, you know, bring up a good point. You know, if you really look at since 1997, you know, nothing's been done over there. Really. And so they've been hanging on with a heartbeat and a prayer. And so that's a good point. No question about it.
But if within the next 5 years, the economy changes, the economy of vanadium and uranium changes, and that everything could change. We would preclude that opportunity if we deny the 5-year term.
I guess I feel like I'm not sure that we would, because again, all we're considering here is what's required at the site. They have the choice to mine or reclaim. And the period of reclamation is, I mean, I don't know, and we don't have evidence on the record how long that would take, you know, but they'll still have a permit in hand. They will just have to start the act of reclaiming. Leaving a site idle for 20 years without being mined or reclaimed is the standard in the statute.
And I don't argue with you about that it's been idle for too long. I guess my argument is that we allowed that to happen. So for us to change the rules mid-game, I think is inappropriate.
We're saying nothing has happened, but in '99, they got this new permit for this particular permit. And in 2012, they got the environmental protection plan. So that's some intent of pursuing mining, it seems to me. We get back into that same argument about what's production and what's development and all of that. I'll make a motion. I move that we approve the application for the second TC.
Second.
Been moved and seconded. Any further discussion? All those in favor?
Aye.
I'm gonna go aye. Those opposed?
Nay.
So it passes 3-2. And the only reason is because there hasn't been anything happening, and they've got that in their portfolio to create an asset that may or may not be there. Probably cause part of the consternation. Okay. We'll take a 13-minute break. I just, the reason, that's kind of what we're about, is to try and figure out. Yeah. And I'm a.
Right?
Well, I don't see anything over there that's happening. Join the cooperative.
Yeah. I'm all about it.
So, if it's some. Huh? Yeah, that's another thing. I think they could have been a little more proactive. Yeah, no, I think they're right. No, I think they're right, but we've got to start, we got to bring things current, so. they're always easy, aren't they? Yeah. You know, I was gonna ask you, I need to ask you a question. I don't know that. I don't know.
Yeah. Yeah.
I know
Right. You want to ask Amy about Mark.
Amy said he wasn't.
Okay. I sent one of them. Said he thought he might have a problem.
When board resumes, could they just ask maybe? When the board resumes, could they just ask?
Hey, Jennifer, how are you? Yeah, did you have an injury? Oh. Yeah. Oh, yeah. Okay. Yeah. Yeah. Yeah, we are. And we're gonna talk about signage. I understand. You can't. Accidents happen, right? I mean, you can't. But you can open my show. Unoccupied most of the year. That's what right next to it. Yeah. See? You're right. Yeah.
Yeah, right as I go, this is how we're gonna do this. Okay, I got it. Well done, Steve.
Oh, I knew that.
Well, the operators really showed up. So, yeah. 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 All right. Two, I like that. Yeah. Oh, my brother and I have figured that out, right on the. We harvested and I cashed my check. That's how it's doing. No, I didn't. So blessed. No, check.
We're not gonna put you guys in the section. Like,
All right. Hey.
sure. Okay.
You know, like, me, I listen. It seems to me like there would be a lot of room.
I think that's what
You know, when we're doing some money.
Oh, I think they. Well, that's not the way. Producing, not producing. Well.
That doesn't even tell raising money. That doesn't talk about how much money you're spending.
Well, the rules are pretty clear. Yeah. If you're not producing, you can go to separate. You don't stop it. What happened here is just fine.
I just thought, you know, like, he's my new in the old days, whenever I come up and say, hey, we don't want that. I had a permit. That's 20 plus straight. So they came to me and said, hey, what are you doing? So they, you know, they come in. I just had no question. Because I was thinking about this. I was thinking about doing that. I was thinking about doing that session. I'm in the middle. I've already actually done separation. I've got a company down there. Down in Gunnison, Ohio. That hasn't been I never. But for years. You're gonna work it together. I'm already
I'm the sole person working. And, it got a little bit.
Well, we'll get it straightened out.
Well, anyway, so what I'm trying to do, because I know. I know.
Hey, Foster, so what will happen is, it'll be probably a little bit similar, so, I'll for that first. I'll handle any questions before that.
I may have that company medicine, that's how you're really talking to them. See, for me to get back into production, I gotta raise about $4 million. Build a mill.
Yeah, and what we'll do is,
Actually,
selling your ore, we'll just have to, handle that through outside vision. I think I put that. That will want to revise the mine plan. Right now.
well, yeah, if we go to that thing, it has to.
Right now.
This is like.
I've been doing that.
But it's just those are actually from your side of the permit. That's where it gets free.
I like that.
But there's still a
I'm
process.
the one that has to pay for it.
Yeah, there's still a process though, because
So,
you'll
I don't know.
you'll make your revision to the plan. Obviously, you're gonna be taking,
The other thing is.
where that big pile is, because that's gonna be excavating all outside. The final, final reclamation plan will look a little different, because I think the original one.
Right, but
So,
you know that
maybe-
big pile that they took out of the, where they built the wild.
Okay.
So that dawned down, okay, it dawned down, so back down. It came out of that stream.
Yep. So that'll be, so yeah, so your reclamation plan might be the same, but then the mine plan is allow for, polished material offsite, but then we'll also do a inert fill notice coming in, just to make sure that it's clean, there's no compressibles in it, so there's like no water or anything that's gonna break down. And so that's part of that revision
You'd have to
too.
like really see what.
Yeah, or maybe when you're just excavating it, just ensuring that it's clean. Basically you don't want anything decomposing in there because it might create a little void.
I did even though it doesn't look like it, but I still go in and
Yeah, well, definitely with all the, your vegetation, natural vegetation, if you were truly abandoned, like, uranium waste, it'd all be grassed over, weeds, yeah. No, your site looks
I taught
actually.
myself. I'm now the two mining companies. And I quote the mining from Oregon, up in Summit, Oregon.
Okay. Yeah, for sure. Yeah, and Tony discussed with me, you can go into TC, so that's a formal
I don't think I
process.
want to right now because if I can sell some of that.
Yeah, then you will. And that's the good thing, like TC doesn't lock you in because if you need to become active again, you just notify us, we'll change you back to the active status, and then you can go.
I had ground penetrating radar down in U of A. And I know what. And so what I'm gonna do is on my week off, one of the deals I made, I work 3 weeks when I get so on my week off, I'm just gonna go in there and start excavating in the hairpin. That's that. I don't have the money to pay for it.
Yeah.
But I could take, a couple $100 a month and put it in the diesel fuel. And, I have a loader. I just don't keep it on site because, it's old and it leaks a little oil. So, you don't want to leave it there dripping oil all over.
Yeah.
My brother is on his claim. he's privately owned this property. If it gets a little on there, I don't get in trouble. So, anyway, so I'm gonna start doing that, excavating that out, because I think if I get down to the 60-foot level on that corner ledge, I think there's enough gold there that I don't have to look for anybody else.
Excuse me. I'm Wally. About shuffling the order, since you're present, if we could move you up. However, it is 11:30. The board wants to ensure that we get a hearing. We have a lot of 60 minutes.
We can do it 30. I don't have a whole lot.
So we can cut the time down. I just threw 60 at
See if we can do 6 and 7 after 8, because he's here.
They believe they can.
Okay, that's good. If it goes 40, I'm not worried about that. I just don't want to go an hour and a half. You know, we had an hour for the allocated for the last one. I'm still in deep, you know.
We could break it.
We could, but I like to be fair. I really like to be fair and keep it, you know, discussion, if you could kind of keep it together.
Yes, sir.
I like to do that.
Especially if it's not a very good lunch.
Right, right.
Right.
It's gonna be a great lunch. Don't be allowed to go marking on the lunch over here. Say bad things about it.
Well, I think we have enough guys. We have enough people in here, don't we?
Yeah. Start rolling with the ball back.
If we could, we'd like to call the meeting back to order, get started here. And with the board's permission, it's been requested that we go out of order. We take 6 and 7 and put them after 8. 8 would like to do, he'd like to do his hearing now. Because he's here and I don't think there's anybody from 6 or 7 here. If there is.
Operator doesn't seem to show up.
Pardon me?
Operator for me doesn't seem to show up.
Okay, so there's no objection from those people when I'm 6 or 7 on the, right? So with the board's permission, would that be permissible to go out of order, and we'll take item number 8? Okay, we'll do that. Go ahead.
Squareman.
Do you swear to tell the truth?
Yes.
Okay, thank you. That's a tough thing to find these days. Thank you.
Yep. Thank you.
Go ahead.
Okay. This is Elliot Russell with the division. Today, we are bringing a alleged violation on the Turquoise Connection Incorporated's Scott Blue 2. That's permit number M 2007-031. The alleged violation is failure to protect areas outside of the affected land from slides or damages occurring during the mining operation, and failure to stabilize and protect all surface areas of the affected land as to effectively control erosion. Scott Blue 2 is a 110-2 permit. It was issued on July 5th, 2007. It is permitted to affect 1.7 acres. Scott Blue 2 is located on public lands managed by the Bureau of Land Management. And as a note, the BLM parcel, the claim boundary, as well as the permit boundary are all the same. The commodity being mined is gold and turquoise, and the approved post-mining land use is rangeland. Slide 3 is an image. The Scott Blue 2 is located in Teller County. Slide 4, the red star represents the approximate location of the Scott Blue 2. It is located just outside of Cripple Creek, Colorado, just to the northeast. And slide 5 is a Google Earth aerial image. The red line is an approximation of the permit boundary. Chronology: on April 19th, 2017, the division conducted an inspection. The division observed 2 off-site erosional features which had been caused by the mining operation. One was located in the ephemeral channel on the northeast of the site, as well as a small head cut developing on the eastern permit boundary. And actually, just to go back, the aerial image on slide 5, the mouse pointer here, this is the upper reaches of Cripple Creek, the actual creek drainage, and that flows from northeast to southwest. And the 2 erosional features, one was located on the north end in this area, and the other, the head cut that was developing on the eastern permit boundary was also on the northern portion, but over on this side. Going back to chronology, on June 1st, 2017, the division mailed the inspection report as well as the reason to believe the violation exists notice to the operator. Slide 7 is a photograph taken during the April 19th inspection. This is on the north end. The yellow dashed line approximates the permit boundary. As you can see on the south end, there's a survey monument, and on the north end, in the next photo you'll see, and that's how I developed that yellow line, is between those 2 monuments. The red dashed line approximates the limits of that northern head cut developing in the Cripple Creek channel. Slide 8, a similar photo, but from across the channel looking back to the southeast there. As you can see, the survey monument again delineating the permit boundary. Slide 9 is another inspection photo. This is the one of the eastern permit boundary. We've got the mining slopes pretty close to the permit boundary there, and the original plan called for a stormwater containment berm to keep offsite water from running down the mine slopes, and failure to implement that berm has created this erosional feature. Slide 10 is just looking up at that head cut along the eastern permit boundary. And before we get to any questions, I'd like to also provide the definition of affected lands. You probably have read this quite a few times, but affected land is defined as the surface area of an area within the state where a mining operation is being or will be conducted, which surface is disturbed as a result of such disturbance. And that definition is CRS 34-103-1.5. And at this point, before we can ask Foster Scott to come up and give his testimony, is there any questions the board would like to ask the division?
Can you explain that stormwater control that was supposed to be there?
Yeah, so in the original 2007 permit application, the applicant submitted a drainage and security map, and this identified the locations of berms along the eastern permit boundary. I'll just go to the map. So there was going to be a stormwater berm in place along the eastern permit boundary, within the permit boundary, as well as a silt fence along the western. And the way the gradient is out there, it runs from east to west. So the stormwater berm on the east permit boundary would keep out any off-site stormwater flowing into the site. And then the silt fencing that was proposed on the western permit boundary would keep any sediment and stormwater on the site from leaving the site. That berm was also proposed to go across the northern permit boundary where the larger head cut erosional feature is located. I'm not quite sure if a berm would help keep out stormwater from a drainage. So moving forward, if a violation is found today, the corrective actions would be an amendment application. And in that, the division will have adequacy concerns regarding any permanent configurations and controls during the mining operation.
And then berms would be within the permit boundary.
Yes, yes. And I actually do have a image of that map that was submitted. It's not in your packets. This is just additional slides. If we go to this here, this map is oriented north to the right, but the black lines here indicate the flow direction, and then in this cross-section image here, which shows the stormwater berm as well as the silt fencing, the next slide I've got is zoomed in on that in that diagram. So this would be the eastern permit boundary. Right at the toe of the berm, it looks like it's going to be a 4-foot wide berm here. And then there is a fence line in place, as you saw from the photos. You know, that fence. I believe in the photos, though, the fence line has been established at the permit boundary and not at the center where the berm should have. Are there any other questions? Okay. I can turn it over to Mr. Foster Scott.
Okay. Have you been sworn?
No,
You swear to tell the truth? Raise your hand.
I do. My name is Foster Scott. I'm president of Voice Connection, operator of the Scott Blue #2. Most of what he said is true. There was a berm on the eastern side. It had eroded away and grass had grown over, so you couldn't see it. I did repair that. On the eastern side where it shows that gulch coming down there, that was there when I first put in my permit. That's not a new erosion. So I don't really think that's part of it. It's been there since since I was a kid. I mean, I've been there since 1968. So that's not there. And then I don't see the need to put a berm on an intermittent stream where there's no primary, secondary growth. It's all alluvial gravel that's come down from the mountains around it for a million years, and it tends to shift. The silt fence was in bad repair, and I repaired that. He was right about that, and he also mentioned on my signage that it wasn't good, and I repaired that. On the north end, that's probably my fault. In a BLM mining claim, if you have a placer claim and you dig up to the edge of it, if it falls in, it just becomes your placer. I realized after studying the Colorado statute that, it caved in on there. So I got it with Shannon Murphy, who's the owner of the property to the north. And I went in there and I rebuilt it and I put the fence back up, and, he didn't have any problem with it to begin with. As a matter of fact, I might mine on his turquoise property over there. So I don't really have any defense. I mean, I did have to repair the silt fence, and I did have to reestablish the berm on the east side, which I did, and I had to redo the signage. And I never, with my machine, left my boundary area, but it did affect it coming in. So I've had this claim for quite a while, and this is the first we ever had to come here. So
you know, I'm the sole operator. I'm the one financially responsible for everything. All the other mine inspectors before, when that first caved in, they just said, don't do it anymore because Colorado doesn't allow it. So I just quit doing it. I didn't do anything. It's been like that for a long time. And so when he brought it up, I went in and fixed it. I'll leave it up to you guys what you want to do about it. And if I make a mistake, I usually go fix it as quickly as I can.
Quick question. Did you make those repairs since the inspection?
I did, before July 5th.
Okay.
Lauren, can I ask you to speak more directly into the?
Oh, sure. Sorry.
Thank you.
Are you in active operation at this point?
You know, I've been active on it for a long time, and I'm still working on it. I've taught myself chemistry in the last 8 years. Right now, I'm a chemist with the mining company in Utah.
Okay.
And I'm going to be the supervisor of a placer operation in Sumter, Oregon, starting. Well, I actually wrote the permit for it with Bill Darden and Alexander, who's a retired forester.
Okay, but is this operations
Yes.
active?
I'm actively working on this operation. I have ore being tested down in Texas, in different places, in Dalhart and in Burleson, Texas. And I've been on the site every year, and I go in and I test and try to find out the best place to start. I went in partnership with Joseph Cruz and Lee Daniel on a different thing called Kingdom Metals. That business failed not because the ore wasn't any good. We had some partners that didn't live up to the part of the agreement and it failed. So in the last year and a half, I've been on a rebound and trying to get funds to go build another mill because I came up with a process to treat tellurium and telluritic ores and to be able to neutralize the effects of tellurium on the metals that hold. So I need to build a mill in order to do that. It's about $4 million. So it's not an easy thing to raise.
Bob.
Just wanted to thank you. I just wanted to understand a little bit more. Elliot in his presentation talked about putting a berm on the north end of the site.
It's a creek.
It's what?
It's a creek bed. I mean, it's a creek. It's not.
Yeah, well, right.
Intermittent stream.
So I guess, I just wanted to sort of get your thoughts. The corrective action that's recommended in the staff recommendation, which I don't think we've gotten to yet, but would be to have you file an amended permit application to work through this stuff with the staff. But I guess I just wanted to take this chance to see if there was if we were setting us up for him to expect you to do something that you don't think is going to work. So do you have a thought on how to otherwise prevent erosion on that north end of the site?
Oh, I put the berm back up there. I put it on a 2-to-1 slope. And right there was where the Cripple Creek actually started descending because this is like a box canyon. It's built up over millions of years. If you just go to the west side where the water drains down towards the Wild Horse Casino, on the other side of the fence, the bedrock is less than 12 feet. And where we're digging, we went 40 feet and never hit into clay. So it's like a box canyon that goes in there. And, I'm sorry, I got lost. Please repeat that question.
Well, no, again, I was just wondering, my sense is what staff is proposing is putting something in place to prevent
And I
the erosion there and to keep
When
it.
I build it up and put a 2-to-1 slope, I believe that will stop anything. It never corroded after I initially was operating there. It hasn't eroded any in the 8 years that it's sat there, and Burhan kept asked me to quit doing it. So I mean, I don't see where and I didn't see in the permit where it said on the north end, other than by mistake, I didn't realize they wanted it across the creek bed in the first place. I don't know anybody that would put a berm across the creek bed down. If there's a flash flood coming down there, you can put up whatever you want, and it's not going to do any good.
Any other questions? So let me just, so you feel like you've pretty much accommodated the staff on what you think it needs, you already done all that. You think you've rebuilt the fence and you repaired the damage and so you feel like you've done what you need to do at this point.
Well, I mean, that's up to you to
No,
decide.
I understand, but I'm asking how you feel.
Yes, I feel I've done a fairly adequate job. And, you know, every time, and Elliot, it's the first time I think he's inspected. And all the other mine inspectors, if they ever had a problem, they just asked me to fix it. And we might, you know, banter back and forth what needed to be done, but I always did what they said. I've always done that. I've always tried to keep my mining clean. I go up at least, I clean it every year. And, this inspection was before I had a chance to get up there because I work out of state. So, you know, but I've cleaned some of it since, but I always take pride in how I present that money.
Okay. Anything else?
So,
Go ahead.
just to follow up, do you know specifically what the staff's recommending?
I do.
I was gonna get recommendations.
Okay.
So before we get into recommendations, I just wanted to just respond to some of the testimony that was brought forth. Bob, you were asking about what's practical. Would it be a berm? There's various ways to control head cuts from developing, and in this type of situation, we would probably have to do something a little more beefy than a berm, like maybe it's some sort of drop structure, some sort of grade control structure, maybe try and channelize it into one area and do a grouted riprap channel to drop that water down, because the mining operation has affected that creek bed equilibrium. He's mined into it about 10 to 15, maybe even 20 feet deep. And with that differential in elevation there, if you have any sort of stormwater flow, it will erode. And these erosional features are a little small, but erosional features don't get better over time, they get worse. Foster Scott was correct with stating that he has established a berm along the eastern permit boundaries, put up the silt fence. He's done his permit sign. He's documented all that, submitted that. There may be some issues regarding the berm on the eastern permit boundary. It appears from the photographs, I have not been on site since that submittal, but the berm may have been possibly built along the fence line, and the fence line is the permit boundary, so that some of the berm is now off-site. So that would be additional off-site lands that need to be permitted and under our office's jurisdiction. And then, yeah, just going from there, I can go into our recommendations now.
Just let me ask you a question. So, but his mining activity's all been within the permit area, right?
Yes, so going back to those inspection photos, as you can see, the mining slope here, you know, was left within close proximity to the permit boundary. So yes, he's mined up to his permit boundary, but then, you know, we've got this erosional feature coming down the high wall. And similarly to the creek channel here, you know, that whole area there has been excavated out and run through his trommel. It's a alluvial placer operation. So there's a pile of overburden located to the south of the permit, or not overburden, but processed materials where all that came from. And that's the same idea as mine pretty close to the permit boundary, as you can see it up in here where that next photo is taken. And that's just, you know, maybe some moving forward, defining that in the application about how your final slopes or your temporary slopes from your mining operation are going to be maintained, at what slopes, how far back from the permit boundary, all those things would be discussed in a revision to the permit.
Can you show me a picture? I'm still confused as to where you're talking about putting a structure to stop erosion.
Yeah, so if you were to do a drop structure in place, like a grade control structure, with the assumption of submitting an amendment to increase the size of the permit boundary, you know, somewhere in this creek drainage, wherever the slope is going to be, where you have that differential, you know, you would maybe a concrete wall with kind of an area for the water to splash down on. And therefore, you don't have that head cut developing upstream.
I know what the structure is, but I need to see
you would
on the map where we're talking about. He's talking about being in the stream.
Yeah, so that structure would have to need to be located across the stream drainage on the north end.
So tell me where the stream leaves the permit.
So the stream enters the permit here and leaves the permit right down over here by his second processing pond.
And then you're saying that he has from, I assume that's north. From the north down, he's taken out 15 to 20 feet of material.
All in here, yes, and that stockpile is located here, and I might be able to zoom in on this. So you can kind of see a little bit quickly. And the red line is just an approximation on the permit boundary using the submitted maps and dimensions. But yeah, so this area here has been mined. There's Mr. Scott's trommel, and then this is where the processed materials have been stocked.
Are those ponds, those dark?
Would you leave that up there when I
Yeah.
So the stream comes down through those ponds and exit back into the old stream.
The drainage. It actually, the stream itself does not flow, or at least when I inspected the site, was not. It's an ephemeral drainage.
So when it flows is what we're saying.
Yeah, when it flows, there's a chance for the erosion coming from natural gradient here into the excavation here. And it's a very small permit. It's very tight in there, and during a revision to the permit to increase the size of it, I would recommend having significant buffers. So if you were to have erosion develop, there would be an opportunity to stop it, repair it, mitigate it appropriately, and before reaching the edge of the permit boundary again.
So 2 questions for you. The first is, was the berm that was constructed a recommendation of the division?
Looking in the permit file.
Or it was originally part of the 2007 permit?
Yes, yeah. So in the application file, there's a series of maps that are required, and Mr. Scott had submitted one map that was titled Drainage and Security Plan, and that was fencing the site to keep people out as well as controlling stormwater. I'm not quite sure who initiated, if that was required, if that came with the application submittals, if the BLM may have required that when he was applying for his permits with that office, or if our personnel asked him to change the permit accordingly.
That was not a recent recommendation.
What's that?
That was not a recent recommendation.
No, that was so the date of that map, I went to it at the end of the slide there. That was in sometime in 2007. It might be date stamp.
Okay, that's fine. And then my second question is about the drop structure. It sounds like this creek has intermittent to very small flow, except for in the possible case of some flash flooding given precipitation patterns. Have you done any sort of analysis on what kind of size structure you're looking for, your flood conditions?
So those are just ideas being thrown out at the time of submitting the permit. If that wasn't addressed, if mitigating, or controlling erosion in the future was not addressed in the submittal, that would be adequacy, and then it would be up for the applicant to propose how he's going to handle or prevent erosion from occurring. Some operators try and do a very gentle gradient, like a 6-to-1. We might not have space for that because of the size of their. Other operators have established grade control structures. So that would be on, the burden would be on him to demonstrate what he's proposing is adequate, and we would verify that.
Okay, thank you.
One more time. Show me on this plan. So I assume to the right is north.
Yep, that's correct.
So that point up there, is that where the erosion is recurring?
Yes.
Approximately.
The drainage kind of flow, is running to the, right of this image up to the top of the middle.
And where was the berm supposed to be?
So this, the berm is supposed to be located, these little black lines, yes, they're located outside, but they're demonstrating what the berm is going to be directing water towards. So the berms were supposed to be erected on the inside of the permit boundary coming around. And then this diagram shows that it's on the inside of the permit boundary. We wouldn't approve an offsite berm. But, yeah, bermed along the eastern permit boundary. This would be like both northern sections as well as a small section on the western. And then if you look at that title there, it says silt fencing, and that the silt fence would be on the west side, and that's what these cross sections
I don't remember
represent.
any berm being on.
Well, just a minute, sir. We'll get up here in just a minute.
So the intent, as far as you read the design, was to build a berm that directed the water to a point in the middle?
Judging from the direction of these are, I think these are showing the flow of water, so the grading black square is going this way. So at a certain point, water would be directed around the site here, but this kind of shows berms being erected and around the operation, back to probably the creek channel here. I believe that's what this map is showing.
So the purpose of the berms was to get the water around the outside of the permit.
That is correct, yes, to control any off-site stormwater from entering the site, creating erosional features down mine slopes.
This map's a part of his permit now.
This was a map that was submitted and accepted and approved in the 2007 permitting process. Are there any other questions? Okay. So the division's recommendations, find the operator in violation of CRS 34-32-116, paren 7, paren 8, for failure to protect areas outside of the affected land from slides or damages occurring during and the mining operation. Sorry. And CRS 34-32-116, paren 7, paren I, for failure to stabilize and protect all surface areas of the affected land as to effectively control erosion. Pursuant to CRS 34-32-124, paren 2, paren A, issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with the conditions of the board order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved with satisfaction of the division. Corrective actions. Require the operator to file an amendment application to increase the size of the current 110-2 permit to include the affected lands outside of the approved permit boundary. The operator shall file a complete amendment application within 60 days of the mailing date of the board order with all materials in approvable form within statutory deadlines. The civil penalty. Pursuant to CRS 34-32-124, paren 7, a person who violates any provision of a permit issued under section 34-32-110 shall be subject to a civil penalty of not less than $50 nor more than $200 per day for each day of which such violation occurs. Please note violations of CRS 34-32-116 7H and 34-32-116 7I constitute a violation of permit provision, specifically condition 1 of the July 5th, 2007 issued permit. Condition 1 stated that the permittee will be bound by all applicable requirements of the Act and all applicable rules and regulations of the board as amended from time to time, the terms of the permit application, the terms of the performance warranty, and the terms of the financial warranty filed with the division. In this matter, the board could find 55 days of violation from the June 1st, 2017 RTB letter to today, resulting in a range of civil penalties not less than $2,750 and not more than $11,000. The board may suspend all or a portion of the civil penalty to encourage timely compliance with the corrective action, as well as compliance with the Act, rules, and regulations. The division's recommendations: fine the operator in violation for 55 days and assess a civil penalty at $200 per day for a total of civil penalty of $11,000, and suspend all but $1,000 if the operator complies with the corrective actions. The portion of the civil penalty not suspended shall be due and payable within 30 days of the effective date of the board order. If the operator does not comply with the corrective actions, the portion of the civil penalty suspended shall be due and payable. Failure to submit any due and unpaid civil penalties shall result in immediate submittal of such penalties to state collection. At this time, are there any final questions?
I have a question. Just looking at the, what they've done wrong in this particular case, compared to a lot that we see before us. And given his willingness to correct these actions, why are you recommending a cease and desist order?
So the cease and desist order, finding the violation, the cease and desist order, corrective actions, and civil penalty, that is our normal course of all violations that are found. Essentially, the cease and desist order we're recommending, as well as to not keep mining and creating more of a vertical displacement before that, an amendment can be submitted to increase the size of the permit boundary and define that before the situation gets any worse. I know a lot of it deals with stormwater and rain events, but the mining site itself could change before any of that is submitted.
Tony?
Also, issuing a cease and desist order allows us to pursue further legal actions if we don't gain compliance, if the operator is unwilling to comply with the order. So we could file restraining order, for instance, against the operator at that point. But if we don't have a cease and desist order, though, that doesn't allow us to do that. So that's kind of part of the chain of actions that need to be taken. So we kind of learned this the hard way in the past, that not having cease and desist orders is problematic in the future if we don't have compliance. Now, we usually have compliance, but it's just a safeguard. We can apply the cease and desist order to any part of the operation, any or all. So if it was the board's pleasure, they could tailor that cease and desist order to certain portions of the site.
Yeah, I guess that's the reason I asked if it was still an active operation. But it just seems like the violations don't merit a complete shutdown of the operation. Unless I'm missing something here. Am I missing something?
And you might want to talk to Mr. Scott again. When I was on site, the site was not active at the time of the inspection, nor none of the support equipment for the trauma was there, and it didn't look like it had been there for a number of years. I actually did question some activity requirements and possibly entering into temporary cessation. I'm not quite sure if it is an active mine site.
And where the resource is probably near where that head cut is, or that at the upper end of that. So I don't know if he has room to continue to operate anywhere else on the site.
Right.
So that's probably another factor.
Okay. That makes sense.
I guess before we wrap up, there was testimony from Mr. Scott saying that he had established the berm, and he had thought that he had fixed the situation. I did have some photos of that if you would like to see what he submitted. And on those photos, I kind of...
So are you saying that he didn't?
So again, just to reiterate, the berm that was established on the eastern permit boundary, I pull into question that he possibly has affected more land outside of the approved permit boundary by erecting it. So there's just limited space between the mining high wall and the permit boundary. So in order to build the approved berm, he would have to backfill that high wall to get enough room. And it appears that he just strung the berm along the crest of the high wall, which then has slopped over off site. So the image on the left, I've delineated where I believe the approximate permit boundary is based on the T-posts. which are located between the two survey monuments. This is the kind of the toe of the berm that has been erected. So I believe this is the small little swale that has created this erosion problem coming down the mine slopes. So you can see that just from this approximation that possibly more land has been disturbed offsite. This would all be land that would need to be permitted moving forward through if the board finds a violation. And then even the fix on the north end, it looks like the slope here has been backfilled. The fence has kind of been reestablished, maybe a little outside of the permit boundary, judging from where I approximate the northern permit boundary at. And then even this here, if there's a berm there or not, or if this has just been graded, there's still a potential for erosion to occur at this mine site. Like you were saying, any localized storm that would flow quite a bit of water down that drainage, you would have an erosional event. And so that way, through this amendment application that's required, we would be bringing up adequacy concerns with controlling erosion in the future.
Okay, I think Mr. Scott wanted you to read that one map up there if you could.
Yep. What, at the north end?
Yeah.
Okay.
The other one that showed, you have a different map on there, and it actually shows where the erosion is. That one with the water. Yeah.
Okay.
That would be good.
Okay.
Okay, so.
Okay, Mr. Scott.
This is Foster Scott again, Reclamation Committee. If you see where I'm standing with the BLM mine inspector right there where he took the picture, the water that's flowing into that is actually coming out from underneath feet. And the water is coming in from here. It's not coming in from this end. It hasn't. I've never seen water come in from that end. I've been there for almost 50 years. I've never seen water come in from the stream. And it's usually run off, and by the end of June or July, it's pretty much dried up. So there's not really, I've never, since I was 10 years old, seen water run over that area, ever. And I've been there a long time. And as far as where it exits, where the water exits on the southwest end, and I was required to put up the rock boundary there for the water to go up over. The only time I ever seen water come up over that, when I was about 15 years old, I seen a thing of water come straight up out of the ground, and that was when it flowed. That's the only time before I was there I ever seen water. I bought an acre foot of water from Victor, Colorado, and hauled it over there, and in the lower pond, I kept that. And with my water usage permit, anything that comes into the back pond as runoff, because that's usually what it is. The Cobble Creek actually comes from where the Sangre Frisco portal is on the other side of this hill. And there's most of the water comes down from Tenderfoot and then that ravine. And this stream bed here hardly ever puts anything in there. It's a very small stream that runs intermittently. So the erosion that you're talking about, on the east side, there's grooves dug by people that mined it at the turn of the century all over Cobble Creek. And he's right. I had to fill in part of that to do that. I mean, that ditch came clear across the property. So, I mean, I'm going to have to, fill that in, fill that up. I'm not opposed to going in there and putting in more 2-to-1 slope. I can build that up. I had like 5 days to do all this. I don't know if you've ever done that much dirt work or if you've ever been associated with that. I was under a little duress, to try to get this done. And I did it by myself with no help from anyone. And so, I'll go in and fix it if there's not enough on that end. Shannon Murphy certainly said I could go in there and build it as much as I need to do. But as far as building something that on the top of a creek bed that monitors it, like you would do a monitoring station to see what the flow is, that thing, The only time we'll ever get wet is when it rains. And all the water that comes into here is groundwater from runoff from the mountains around it, and it comes in underneath, and it comes out in that pond, the back pond. The front pond, I put all that water in there myself, and it's clay based. Now, I'm planning on draining all that, even the water I had, just to get it out of there, so I don't have any of this trouble anymore. But I've just never seen a significant amount of water here, and I moved to Cripple Creek in 1968, and I've hunted rabbit on there all my life. I know that area probably better than almost anybody in the district. I found the first precious opal in Cripple Creek, and I'm the only one with a piece of turquoise in the Smithsonian Institute that I found in Cripple Creek. I've prospected it and done things on it since 1968. I seen where he took a picture of that, and it looks like I didn't quite fill that north end in enough, and I'm willing to go in there and finish doing all that. And on the east side, I can build that berm up another couple feet, and I'll go up there and shovel that stuff off, wear it down somebody else's property, if that's what it takes. I just need the ability to do it. I've never ever said I wasn't going to do anything, so I just ask you guys to give me a little leniency. I mean, I could understand if I was here. If I've had the claim for 20 years, I could see if I had done this, and I was here several times, that there might be an issue. But at one time, Burhan, I think, invited people up to my claim to show them how clean small operators could be and everything like that. So, I'll do what you guys ask. But if you find me $11,000, it's pretty much signing my death warrant.
Any questions or comments?
Do you see what they've recommended, and can you do it?
I can't go on somebody else's property and put it under reclamation. No, I can't do that. I mean, I can't do it. I can build up from my side, and I can put the berm inside. It'd take me another 2 foot off of my claim. That's no big deal. They say that there's no more there. I would argue with that any day, any time, with anybody, and I'll do it with a PhD chemist. There is so much value in that property. I'll never give it up. You can do whatever you want. I'll keep the property for the rest of my life. I found adequate amounts of platinum, palladium, rhodium, iridium, gold, silver that I'll never give this claim up. And,
This picture, is this your north boundary?
yes.
To the left is north, and to the right is south.
It's actually facing a northeastern side, the meanders. And then it doesn't show it.
But the property to the north of your boundary is not yours, or the guy you're leasing.
Shannon Murphy Mining, Colorado.
Okay.
He was just up there with me on the fifth, we were talking about.
Okay.
And then the berms over here, there's some fences here that it doesn't show in here. And those are points of volatility in this claim because, and I'm friends with the turquoise mine there, but he has that fence. And I'm not going to go on there, and I'm not going to do anything inside of that fence because I don't need to go to court.
Well, that kind of leads me to another question. Do you have the capability of expanding your permit boundary to cover the areas that you've gone outside? Okay, whether you have the capability to expand your permit boundary to basically cover the area where you've disturbed outside the boundary. I'm talking about anywhere around it. Okay. What about in the areas where you're outside?
That is the northeast side, and I've already rebuilt that. The owner of the land was there with me. He actually told me where I could go dig on the property, put more dirt in there if I needed to.
So you could expand your permit boundary then?
Well, not necessarily because I believe that's I think they incorporated part of that into the city, and there's no mining in the city of Cripple Creek. So I don't think that's possible. I can repair it for sure.
So what you're saying is your permit area is what you own.
Yeah, and if you look at the other map that I have, which is a horseshoe, it's a hairpin that I'm gonna do inside of that plane. And it's 100 foot wide. And it's 110 or 112 at that end where he has a straight line going east and west. And 795 feet long. By the time it gets to the end of where my pit area is right now, it's only about 105 feet wide. But if you do a 20-foot high wall and you do a 2-to-1 slope, you still have 10 foot of road left there. So I can do that. And I can do that hairpin. And by the time I get down to where you see the large body of water there, I could actually be almost 60 foot deep. Because then I did a 2-to-1 on the outside boundary because that's what I was asked to do. I have straight up, and I have a permit that allows me to dig from 20 foot straight up and down. And so when I get into the final leg of that hairpin, I can go down straight walls. And of course, I'll make sure I have a thing over my, because I don't want to get buried. I was buried in 28 foot in the ditch in 1992. I don't want to go through that again. So I believe I have a lot more to do there. And then, I can always design somebody to come in there and put concrete. And I can go down a lot further. Engineering is something that can make things happen. It takes money.
So are you saying you're gonna go down another 40 feet deeper than where those ponds are now?
Probably 50 foot
Deeper?
Yes, sir. It
So,
doesn't mean that I'm gonna be right up against there. If you look at the mining plan, it's like a hairpin, it's just like a paperclip. So we're coming down, let's see it. Maybe it's better this way here. So we're coming down this side of the plane, which would be here. And then it comes here and I'll have to stay back a little ways to stop doing that. And then I go back down this way and it heads downhill naturally anyway on this side, on the west side, it already goes down. So by the time I go down my 20-foot area on the west side, when I start doing the run down the center of the plane, which will be, it'll be within 40 foot inside the boundary, I can go down another. By the time it gets done, it should be 60 foot deep.
well, I hope you understand that what they're saying is you got to redo your permit.
When I get to that point, but the permit already allows me to do what I just told you.
No, what they're saying, what the staff is recommending, the action this board take is that, number one, we issue a cease and desist order, which means you can't do anything out there, including mining, except reclamation from now on until you submit a new permit in effect, and tell the staff how you're going to protect, even in the very slight times that there's water running down this channel, it's not going to back cut up off your property. You're going to have to show them how you're going to do that. And you're going to have to come up with permission on how to fix it outside your permit or your ownership or whatever. I just want to make sure you understand that's what they're recommending,
I understand.
is that you're stopped as of now, and you're going to have to redo your permit. And you're going to have to answer these questions about the water and the head cutting. And you're going to have to answer about the property that you don't own. And how are you going, can you come up with an agreement with the guy north of you that allows you to do it and put it in the permit? Or I don't know. I don't know what the answer is, but that's what the staff is asking the board to take action.
I can get a letter from Shannon Murphy tomorrow. As soon as I get a hold of him on the phone, that allows me to go in there and fix that. That's not a problem. And I can build this eastern wall up with the loader, and I can put the berms in on the property line, and that's not a problem. 5 days was a little bit rough to try to get it done. And I can do the 2-to-1 slopes on all the outside boundaries. That's not a problem. I don't have a problem with that.
Well, it's just going to have to be done through an amendment on your permit.
Right.
But, you know, I still have to be able to go in there with a loader and fix it.
Sure.
Yeah, well, the cease and desist will allow you to do reclamation.
But I don't know if that's considered reclamation, putting in two to one or what.
Mhm.
Or you mean just,
Well, that'll be between you and the staff as to what's reclamation and what
I mean,
isn't.
I'm willing to do whatever.
If you're going to take it to 2 to 1 and run it through your trommel, that may not be reclamation, but if you're doing a 2 to 1 to get in your compliance with your bonding plan,
Yeah. No, I'm not running anything through the trommel. I'm gonna, you know, I'm trying to do a different phase of the operation. I'm not actively doing that at this moment. So last year was the last time I did that, and I don't intend on doing that. I do plan on, you know, starting to dig on the property. So I mean, I'm willing to go in and fix whatever. Needs to be. You know, probably won't happen until August.
Yeah. How much communication have you had with our staff? I mean, it sounds to me like we could,
Some,
huh?
a little bit.
I mean, it sounds like you're amenable to, you know, doing what's asked. I don't know whether you feel comfortable or not, or if you got any suggestions, but let's stay on the subject. You know, I just need to get answer the questions we're asked, so. I don't know what. You know, I don't know, you know, you gotta turn in, you gotta work with them on the amendment, and the amendment will cover, I think, if I'm correct, amendment to your, and you probably need them to help you draw up that amendment so that you'll know what to put in it to the plan. And, so that it can be solved. Is that a fair assessment? So. I don't know. It sounds like you want to do it, but we don't know what to be done. Somebody needs to delineate. You really don't have a serious weather problem right there either. I mean, you get some snow, but it's not, it doesn't knock you out. Maybe January or February is about it.
I can't, you know, usually by the end of October, it's snowing up there and the ground's frozen in place.
That's true.
And from
You got any
October,
moisture
so
in it.
usually May or April, May, June. So, you know, that's,
What's that? Okay. All right. You got anything further to add? I mean, I think we've covered it, but I'd like to close up testimony so we could start discussing it if we could.
yeah, I'm, the only thing you know, I'm willing to fix whatever. That's all.
Okay.
Whatever they've ever asked me to do, I've always done. That's it.
All right, let's see what we can determine here.
I do have one question for the division, if I could ask.
Yeah, sure.
If we were to customize the cease and desist order, how would you recommend we do that?
So the cease and desist order that I had recommended already has flexibility in it where Foster Scott could request in writing to do
Okay.
any sort of activity, and then we would approve that in writing. So there's
Okay.
nothing over the phone, or there's no. So there is flexibility built in.
I missed that when I went through it.
This is Wally Erickson with the division. I just want to clarify that we need the cease and desist to motivate Mr. Scott to provide us designs prior to going out and just doing the work. As Elliot's photos had shown, some of his proposed repairs may have exacerbated the problem. And so we want to make sure that these designs are submitted for review and approved prior to implementation.
Okay.
And the same thing with the civil penalty is encouragement to gain compliance, and Mr. Scott appears to want to comply, so these will just be placeholders, and then the cease and desist will be lifted once the corrective actions have been resolved. The suspended civil penalty goes away when the corrective actions are resolved. So.
Any additional discussion or Anybody want to put something in a motion?
Are you closing testimony?
Yeah.
Yes, I am closing testimony.
Yeah, that part. Well, I have some thoughts. I mean, I think these violations seem way too high, too harsh for someone who has made the effort to comply. And obviously has operated there for quite a bit of time without really being before this board and having a lot of complaints against him. It sounds like the real problems here are part of the original stormwater plan. It doesn't sound like that was really well developed, nor does it truly sound like those actions suggested in the stormwater plan were taken as promptly as they should have been. I think if we're really concerned about creek flow here, we could do some monitoring at the surface level, although it sounds like the water here is really groundwater. But in order to make everyone sleep better at night, you could definitely do some monitoring up top. And it sounds like it doesn't seem fair to force the expansion of the permit when someone's already trying to make it right. But that said, it sounds like there is quite a bit of expansion suggested at the site, and that these stormwater plans as they stand are going to be inadequate for another 50 feet of digging over time. And yeah, I recognize the concern that erosion does get worse over time. It doesn't just repair itself. It sounds like we do have some good options with this 2-to-1 slope on the inside of the boundary, and that if the division is able to work with Mr. Scott up front and approve those plans, then it sounds like he's willing and able to do what the division asks without huge penalties and financial fines as well. So I think there's an option here where we don't have to be as harsh as some of these suggestions are. I think we have an operator who wants to make it right, and we can suggest that.
Anyone else? Someone needs to
Make a motion.
fix some sort of motion.
I'll make a motion. Before I do, my concern is that in order for him to do what we're telling him he has to do, it's going to take some work and some time with the adjacent property owners, whoever they be. And I think it's fair what we're asking. I mean, this is one of the things we concentrate on is when somebody gets outside of permit. Permit's intended as a permit. So that said, I move that we find the operator in violation of CRS 34-32-116, Pren 7, Pren H, for failure to protect areas outside of the affected land from slides or damages occurring during a mining operation, and CRS 34-32-116, Pren 7, Pren I, for failure to stabilize and protect all surface areas of the affected land as to effectively control erosion. I move we issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with the conditions of a board order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. Corrective actions to require the operator to file an amendment application to increase the size of the current 110 Pren 2 reclamation permit to include affected areas outside of the approved permit boundary. The operator shall file a complete amendment application within 60 days of the mailing date of the board order. All material in an approvable form within statutory guidelines. Find the operator in violation of 55 days and assess the civil penalty of $200 per day, or a total penalty of $11,000 with all but $500 suspended if the operator complies with the corrective actions. The portion of the civil penalty not suspended, which would be $10,500, shall be due and payable within 30 days of the effective date of the board order. If the operator does not comply with corrective actions, the portion of civil penalty suspended. I'm sorry, I got off track. Can I back up?
Yes, please do.
Let me start over the sentence. The proportion of the civil penalty not suspended, $500 shall be due and payable within 30 days of the effective date of the board order. If the operator does not comply with the corrective actions, the portion of the civil penalty suspended, $10,500 shall be due and payable. Failure to submit any due and unpaid civil penalties shall result in immediate submittal of such penalties to state corrections.
Anybody hear a second? I haven't heard one so far.
I would move to modify your motion to a $100 penalty rather than 500.
I don't know how to do it. Do you need a
Well,
second?
you can accept that, I think.
Just need to amend the motion.
Yeah, if you concur with the amendment, that would be adequate. You can just say you
If you
concur with
could,
that.
yeah, if
amendment.
you would concur with his amendment, rather than it being 500, it'll be
Okay,
100.
I concur with you.
I'll second that.
All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Hearing none. Mr. Scott, I just want to say, I hope you'll go right now and set up a time to sit down with the staff, and I think you can get it all worked out. And, we want you to be successful, and I know our staff does too, and appreciate you coming up today and telling us about it, but, we've got to get it rectified, and it sounds like you're willing to do it. But I think these people can help you make, so you follow a good plan. Our folks can help you maybe do things more economically and solve your problem so that you don't have to go back and do it again. So, yeah, so if you could get that course, that collegiality together with the staff, that'd be great. Thank you very much for coming. Okay, we're going to recess for lunch. Bob, when do you want to come back? Quarter after.
Thank you. I do. You're holding it a little like this, Wally. So I'm going to pass out my staff presentation form. This is to summarize this item. I don't actually have a PowerPoint presentation put together, but this will help kind of summarize the action item. All right, how you doing? That's all you can do.
Is
Just
this
survive.
Front Range Buffalo?
This is Front Range Buffalo. Sorry, I probably should have announced that first before I started handing out the presentation. Thank you. I've been notified by the operator, which is Mark Dolphin with Front Range Buffalo LLC, that he was in a car accident and he's physically unable to make the hearing. So he doesn't plan to show, I don't think, and no representative is to be here. So don't expect it. This action item is for consideration of the operator's request to reinstate a revoked permit after past due annual reports, maps, and fees have been submitted. This is for file number M 2004-041, White Buffalo Quarry. The permittee is Front Range Buffalo LLC. This quarry is permitted. It's a 110C permit for 9.9 acres. It's located in Larimer County. The operator mined sandstone, and the post-mining land use is rangeland. And the division holds a bond of $13,000 in the form of a CD for this site. I'm just going to go quickly through the chronology here. There's not a lot here. On January 10th, 2017, the division sent to the operator a notice of violation for MV-2016-063, notice of civil penalties, cease and desist order, and notice of a formal board hearing. And this was for failure to pay annual reports, fees, send the reports, and the maps. February 23rd, 2017, there was a board hearing held for consideration of permit revocation and finding of the financial warranty subject to forfeiture. On March 13th, 2017, a board order was sent to the operator ordering the permit revoked and finding the financial warranty subject to forfeiture. The division went to inspect the site to see if the financial warranty we held was adequate to reclaim the site. And we inspected the site on May 17th, 2017. We found the site to be reclaimed, and thus the financial warranty of $13,000 is sufficient. And I just wanted to add, in talking with the operator, the past due annual reports were for 2015, 2016, 2017. And Mr. Dolphin believed that the site had been released. The site had been reclaimed several years ago, and he thought it had been released already, but no release request was ever submitted for this permit. On May 24th, 2017, the division did receive the past due annual reports, maps, and fees for 2015, 2016, 2017, and the civil penalty that was assessed in the amount of $323. And on May 24th, that same day, the division also received the operator's request for permit reinstatement. For staff recommendations, pursuant to CRS 34-32.5-124, parent 6, parent B, if the board suspends or revokes the permit of an operator, such operator may continue mining operations only for the purpose of bringing such operations into satisfactory compliance with the provisions of such operator's permit. Once such operations are completed to the satisfaction of the board shall reinstate such permit. In this case, the board revoked the permit for failure to submit the required annual reports, maps, and fees for 2015, 2016, 2017. The operator did submit these items and the civil penalty that was assessed, which brought the operation into satisfactory compliance with the provisions of the operator's permit. Additionally, the site has been reclaimed and the operator wishes to request a release of the permit if it is reinstated. Therefore, the division staff recommends the board reinstate the permit. This completes my presentation.
Do I hear a motion?
I don't understand why he wants it reinstated if it's already reclaimed.
Well, you can't actually release it until it's active again. So now that the board has already revoked the permit, we can't actually process a release request. So basically, he asked about this when I did the inspection. I said, look, we're going to have to, first of all, you're going to have to get compliant. You got these past due annual reports and fees. You got 3 years worth. You're going to have to get compliant with that. Once you get compliant, we're going to have to ask for reinstatement. Once we do that, then you can officially ask for your release request. So we're just kind of, there's a couple of extra hoops here to jump through because the permit has already been revoked and the financial warranty has been found subject to forfeiture. But in this case, we have an operator that actually got compliant. So we're back on track. But we division staff do not have the authority to make the permit active again.
So otherwise, we could cash the bond and then refund it to him because it's already reclaimed.
Sure, we could find something to reclaim. I don't know. Technically,
That might be.
we could forfeit it.
We would bring it for final forfeiture. He hasn't been in compliance, but he has, so this is not an unusual request.
There could have been civil penalties, extra civil penalties assessed, potentially. It could have cost them more. I think this $1,292 got him compliant, and it costs nothing to ask for a release. So if he ever wants to permit in the future, or he has, you won't have this mark on your name, I guess.
Make a motion.
Okay, I appreciate it.
Pursuant to CRS 34-32.5-124-6, Pren 6, Pren B, if the board suspends or revokes the permit of an operator, such operator may continue mining operations only for the purpose of bringing such operations into satisfactory compliance with the provisions of such operator's permit. Once such operations are completed to the satisfaction of the board shall reinstate the permit. The operator has submitted the past due annual reports, maps, and fees, and the civil penalty of $323. Additionally, the site has been reclaimed and the operator wishes to request the release of the permit after it is reinstated. Therefore, I move we reinstate the permit. Will that do it?
That's good.
That will.
Yeah. Your second? Maureen, you want a second? Been moved and second. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Hearing none, motion passes. Thank you, Amy.
Thank you.
Agenda item number 7. Oh, do you swear to tell the truth?
Yes.
Well, we've already got you on record. Thank you.
Hello,
Okay, Jerry.
my name is Jared Ebert. I'm with the Colorado Division of Reclamation, Mining, and Safety. And this is a enforcement hearing for the 120th State Partners site, permit number M 2001-085, operated by 12085 LLC. This is for consideration of possible violation, cease and desist order, corrective action, and civil penalty and/or permit revocation for failure to comply with the conditions of a permit and/or failure to provide all monitoring information required as part of the approved reclamation plan with the annual report. This site is located about a half mile southeast of the South Platte River in the town of Henderson in Adams County. You can see Brighton Road right there, and it's in between 120th and 124th. This is a 112 construction materials operation. The permit area is 51.6 acres. They originally mined sand and gravel at this site, however, at this time mining is complete and they're conducting reclamation. In the primary area that's left in the permit area, they mined a 20-acre pit that they are slowly backfilling with inert material. And the remainder of the area they're using as a recycling facility for construction materials. They bring in asphalt and concrete, reprocess it and sell it. The post-mining land use for the site is general agriculture. The financial warranty held is $368,590. And I evaluated that and it appears adequate. So basically, these colored polygons on the map show the permit area with the exception of this blue polygon that was bond release. That corresponds to these areas over here on the right-hand side. The primary area where their current operations are going is in the bottom left-hand corner. All right, go into some chronology of events here. On October 16, 2014, the operator submitted technical revision number 6, which included a groundwater monitoring plan. They were to install 2 water wells, groundwater monitoring wells, one there, one down here, there and there. And they were to monitor those 2 wells for water levels on a quarterly basis. And they were to submit the results of that monitoring in their annual reports that they submit every year. And that technical revision was subsequently approved on November 17th of 2014. I conducted an inspection of the site on March 15th of this year. And upon review of the mine's records, I found the operator had not been submitting the required groundwater monitoring data with their annual reports. I cited a problem for delinquent groundwater reports and imposed a corrective action deadline of April 19th to submit the groundwater reports to for the first quarter of 2014, the fourth quarter of 2014, all the quarters for 2015 and 16, and for the first quarter of 2017. Subsequently, the corrective action deadline, I extended out to May 11th at the request of the operator. On May 10th, I did receive a response. The operator had conducted some groundwater monitoring at those wells, but they had done on an annual basis and on the quarterly basis, which is required by their permit. So given this, I sent them a reason to believe the violation exists and a notice of this board hearing on June 22nd, 2017. So basically the reason for the violation, the operator was required to conduct groundwater monitoring on a quarterly basis and submit that data with their annual reports. At the time of my inspection in March, they hadn't submitted any data. And then once requested to submit the data they submitted demonstrated they hadn't monitored the proper frequency. So I recommend, or the staff recommends, that the board find a violation for Construction Materials Rule 1.115 or 1C for failure to provide all monitoring information required as part of the approved reclamation plan, and with the annual report pursuant to CRS 3432.5-124 for failure to comply with conditions of the permit. I do not recommend a cease and desist order at this time. Corrective actions: order the operator to initiate and comply with the approved groundwater monitoring plan beginning with the second quarter of 2017. Order the operator to submit the results of the groundwater monitoring to the division with their annual report due on their anniversary date of the permit, which is July 25th, yesterday. In terms of civil penalty, pursuant to CRS 3432.5-124.7, a person who violates any provisions of a permit issued under CRS 3432.5-101 shall be subject to a civil penalty of not less than $100 per day or more than $1,000 per day for each day during which the violation occurs. In this matter, the board may assess a civil penalty in the amount of $3,400 to $34,000 for 34 days of violation. We determine that based on 34 days of violation from the date of the RTB letter on June 22nd to today's board meeting. And that is what I have.
I have a question.
Sure.
Why the monitoring?
Well, many of the gravel pits along the South Platte River are either in line with the slurry wall or they're being backfilled, and there's a potential for groundwater mounding to occur on the up gradient side of the fill area in this case, and shadowing and drawdown of the groundwater table on the other side of it. So those monitoring wells were installed to basically determine if any shadowing on the down gradient side and mounding is occurring on the up gradient side.
So this thing that he submitted with the levels, what does that tell us?
Not a lot. The reason I think it was judged originally to initiate monitoring on a quarterly basis, because that better captures the seasonality of the fluctuations of the groundwater table. And on an annual basis, and they did it at various times throughout the year. It wasn't even a consistent time of the year. With that data, it would be hard to make any assertion as to what the groundwater table is actually doing out there.
Are you at all concerned about this one, the last one they took on May on the south well at 16 feet?
Yes. Yeah. I haven't seen any, while I was out there, I didn't see any like pooling of water behind them, and I didn't see any impact. So there's nothing currently that I'm aware of that's being impacted by a rise in groundwater level at that particular mine. But being in Adams County, the raise in groundwater level around these pits is very much of concern of the surrounding population. I get calls frequently about it. So accurate and adequate and a groundwater monitoring, it needs to occur at these sites for sure.
Jared, have you seen any reluctance on the part of the operator to not comply with this new?
No, I haven't.
Standard?
I'm actually surprised they're not here. I had spoken with them, and we had proposed this to be put on the consent agenda, and they were considering it, and I guess decided not to do that because I never received something. But otherwise, they were very easy to work with. It was a pretty clean operation. I think this just kind of fell through the cracks, unfortunately.
I don't have a motion, but I have a comment.
Okay.
I think this is pretty serious that they didn't do what they were supposed to do. I think the fine ought to be at least the minimum of $3,400 without anything suspended. I'm tired of making motions.
So we'll just keep in mind your comment then.
Yeah.
I need a motion for it.
Okay,
You don't have to pay any attention to Tom.
I know. I move we find a violation of construction materials rule 1.15, parent 1, parent C, for failure to provide all monitoring information required as part of the approved reclamation plan with the annual report and pursuant to CRS 34-32.5-124 for failure to comply with the conditions of a permit. By the way, this is for permit M-2001-085. As for corrective action, order the operator to initiate and comply with the approved groundwater monitoring plan beginning with the second quarter of 2017. Order the operator to submit the results of groundwater monitoring to the division with their annual report due on the anniversary date of the permit, due each year on July 25. As for civil penalty, I move that we assess a civil penalty of $3,400 for 34 days of violation, with all but $500 suspended. The payment of any unsuspended portion of the civil penalty due and payable within 30 days of the effective date of the board order.
Any discussion? Amendments?
Discussion, I still think it ought to be 3,400.
All those in favor signify by saying aye.
Aye.
All those opposed, same sign.
Aye.
Let the record show that Mr. Brubaker was a no vote.
4-1.
Why do you think it was
Thank
so
you.
serious? Why do you think it was so serious?
Okay, agenda item, what is it, 9?
At annual day.
Okay. Thank you.
Thank you.
Yes? Oh, 9 was? Oh, okay.
Oh, that's right.
Michelle, thanks for being on the ball.
It's all right. You're welcome, and I promise to tell the truth.
I'm telling you, she's efficient. She needs a raise, guys.
Thanks. I'm Michelle Ramirez, Program Assistant for the division. And this presentation is for file number P 2012-006, the Bueno Mining Mill in Boulder County. The prospector's name is Gold Hill Minerals, Inc. The commodity is gold and silver, permitted on 0.065 acres. They have 2 existing cash bonds, which we'll discuss a little bit later here. This hearing is for consideration of a possible violation, cease and desist order, corrective actions, and civil penalties, permit revocation, and finding the financial warranty subject to forfeiture for failure to submit the 2015 annual fee report and map and the 2016 annual fee report and map required under CRS 34-32-116, parens 4 and Rule 5.6. The chronology was provided in the July 14th packet and is consistent in today's presentation before you, with the addition of a little highlighted asterisk. After the packet was submitted to you July 4th, the division received the reason to believe letter from to the operator, which was returned marked return to sender, no such number, and unable to forward. And for record, the division requests that the board take the following action. Find a violation according to CRS 34-32-116, parens 4, and Rule 5.6 for failure to submit annual reports, maps, and fees due July 9th, 2015 and 2016. Issue a cease and desist order prohibiting all prospecting activities for NOI file P 2012-006 until the prospector has complied with the corrective actions to the division's and/or board satisfaction. Within 10 days from the effective date of this board order, submit the delinquent annual reports, maps, and fees totaling $172, which were originally due July 9th, 2015 and 2016. In this matter, staff recommends a civil penalty of $3,400, which is the 34 days times $100 per day, with all forgiven except $1,000 if complied within 30 days of the date the signed board order is mailed, unless otherwise specified by the board order. Where corrective actions are not completed by the board ordered correction date, stated in the board order, the suspended civil penalties are due in full within 30 days of the deadline for board ordered corrective actions. The division further requests that the board take the following actions. To CRS 34-32, -24, parens 6, parens A, and revoke permit P 2012-006, pursuant to CRS 34-32-118, parens 3, parens A, parens Roman numeral 3, and parens B, find the following financial warranties subject to forfeiture for permit P 2012-006, cash bond number 1105 in the amount of $2,000,
and cash bond number 1219 for $16,500. And there are no violations associated with this permit. The legal basis for forfeiture of financial warranty and required notifications are provided in this presentation before you. And if there are any questions?
Do we know if the bond's adequate?
I wasn't given an answer. I believe it is.
I do believe that it is adequate based on my experience with this site. But prior to final forfeiture, we'll be doing inspection.
I guess I have a question, just for my information. This being an NOI, why is it not done in executive session?
It's post 2008.
Okay.
So
Okay.
remember that.
That explains it.
I was curious too.
Yeah.
Anything prior to that
Right.
is probably confidential unless it's been modified, which would make it non-confidential. Anything post is non-confidential for the most part.
I forgot that.
I didn't know. Any questions or comments?
You know, we have a number of these, maybe in order to expedite things unless you have changes to make to staff recommendations. It's already been read into the record, but it's up to you guys.
Fine with me.
I move staff recommendations on P-2012-006.
Is there a second?
Second.
We'll move and second. Mr. Randall got the second in first. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Hearing none, we'll move on.
Thank you for that, Mr. Waldron.
Yeah, that's great.
A few more of those too.
That's a motion you're willing to make?
I noticed you jumped on that.
We can agree.
Yeah. Yeah, you were unanimous.
Yeah.
Okay, thank you.
This is the one I want to see how this is going. I can still stay in here and listen, can I? I just won't vote. I know about this property a little bit. I don't know what the subject is, but I cannot vote. I want to hear, but I'll just recuse myself from voting.
Again, Michelle Ramirez for the division. This presentation, and I will tell the truth, this presentation is for file number P 2014-021. Operation name is Easy Ranch, Easy 6 claim. It's in Custer County. Prospector's name is Eustace Zacher. I believe I pronounced that right. The commodity is gold and silver on permitted 1.2 acres. There is an existing cash bond. To my knowledge, the bond is adequate. This hearing is for consideration of a possible violation, cease and desist order, corrective actions and civil penalties, permit revocation, and finding the financial warranty subject to forfeiture for failure to submit the 2016 annual fee report and map required under CRS 34-32-116, parens 4 and rule 5.6. Again, the chronology was provided in the July 14th packets and is consistent in today's presentation before you. The division requests that the board take the following action. Find a violation of CRS 34-32-116, parens 4 and rule 5.6 for failure to submit the annual report, map, and fee due July 2nd, 2016. Issue a cease and desist order prohibiting all prospecting activities for NOI file P 2014-021 until the prospector has complied with the corrective actions to the division's and/or board satisfaction. And within 10 days from the effective date of this board order, submit the delinquent annual report, map, and fee totaling $86, which was originally due July 2nd, 2016. And the staff recommendation, you've already agreed to keep going. The division further requests that the board take the following action pursuant to CRS 34-32-124, parens 6, parens A, and revoke permit P 2014-021. pursuant to CRS 34-32-118, parens 3, parens A, parens Roman numeral 3, and parens B, find the following financial warranties subject to forfeiture for permit P 2014-021. There's cash bond number 1002-105 for $4,000. There have been no violations associated with this permit. And the legal basis for forfeiture, the financial warranty and required notification. Notifications are provided in this presentation before you. Any questions?
I think that, just to be clear, and that's right into the record, the recommendation for penalty was 3,400 with all given $1,000.
I move that we accept staff recommendation for NOI file number P-2014-021.
Second.
All those in favor?
Aye.
Those opposed, say no. Let the record show that I didn't vote. Okay. What do we got next? 12? Is there 12? Agenda item 12?
12.
When you're ready, you can swear him in.
Oh, I'm sorry, Scotty. Do you swear to tell the truth?
I do.
Start paying attention.
That's my job.
Good afternoon. My name is Scotty Tate, and I'm a program assistant for the RMS Minerals section. I represent the division. This is a formal hearing for the West Bayou Creek Pit, permit number 19M 1981-005. This matter is being brought before the board for consideration of violation, civil penalty, cease and desist corrective actions, rent verification, and finding the financial warranty subject to forfeiture for failure to pay the 2015 and 2016 annual fees, for failure to submit the 2015 and 2016 annual reports and maps, and for failure to pay the civil penalty of $791 assessed for violation MV 2017-023. This site is in Adams County, 5 miles east of Strasburg. The chronology is located in the presentation package that I passed out to each of you. In regards to this matter, the division does hold a certificate of deposit bond in the amount of $24,100 for this site, and it is adequate. The last inspection was performed on May 19, 2015 by our formal environmental protection specialist, Tyler O'Donnell. As of today, the operator has failed to pay the 2015 and 2016 annual fees, has failed to submit the 2015 and 2016 annual reports and maps, and has also failed to pay the civil penalty of $791 assessed for violation MV 2017-023. It is the division's recommendation to affirm the division's findings of violation MV 2017-023, to revoke permit 19M 1989-124 pursuant to CRS 34-32.5-124.6, and to find a financial warranty subject to forfeiture pursuant to CRS 34-32.5-118, and also to issue a cease and desist order from all mining related activities for this permit.
Would you give me that permit number again? That's what I got on my sheet.
M 1981-005.
Okay, that was 89, yeah.
Thank you. It's 89.
There's some,
81-005. I apologize for that.
it's not the right county or something.
The CRS citation was off too.
M 1989-005. 1981-005, not the 9, don't lose the 9, 1981-005.
Okay.
But on my sheet, it shows that being Blaine Schmidt in Adams County. And it shows Yockledge, Houston being in Custer County, 1989-024.
You're referring to the agenda.
Oh, that's the next, that's actually my next.
But I'm pretty sure that somebody with a West Cliff address has Custer County versus
Yep.
Strasburg being.
I think we just have the wrong one then.
Yeah, I think we have something mixed up there.
Yeah.
So I think this should.
So read it all again, Scotty.
From the beginning.
I think to correct this should be 1981-005, Blaine Schmidt Ready Mix LLC. And that will correct it for this one. The next one is going to be, Houston.
Yeah, but that's still in, it shows here, it's still in Adams County.
The Blaine Schmidt one is in Adams County. The other one should be in Custer County. So I think it's just done.
By the way, Mr. Chair, this is one of the things we want to change in rulemaking so that staff can just make these determinations. So we're not bothering you guys with what, making a decision on whether they submitted their annual fees maps and reports. Either they did or they didn't.
Sounds good to me.
Yeah, right.
From our lien process.
Yeah.
Well, let's get into the next one. I'm still a little cloudy on this. Let's go ahead.
Well, so can I just, in order to correct the record, I just want to say that this is Mr. Blaine Schmidt. It's file M 1981-005, Schmidt Ready Mix LLC in Adams County. And I believe the rest of the information should be.
Okay.
I move staff recommendations on M 1981-005.
Second.
It's been moved and seconded. All those in favor?
Aye.
All those opposed, same sign. Motion passed. Okay, let's go on to the next one. I still got it. Try this one more time. Thank you. Thank you. You're welcome. Yeah. She still got him here on that one way it's passed. Yeah. That's what I brought.
Glad somebody's paying attention.
Yeah.
Yeah.
Once in a while.
Yes.
Okay.
This guy.
This is a formal public hearing for the Shangri-La Pit, permit number M 1989-024. This site is located in Custer County. Permitted acres of 9.90. It's a 110C. The chronology is located in the presentation packets I passed out to each of you, which list all correspondence relating to this matter. The division holds a certificate of deposit bond in the amount of $5,000, and it is adequate. Site is 1.5 miles southwest of West Cliff at 7,800 feet. This matter is being brought before the board for consideration of violation, civil penalty, cease and desist, corrective actions, permit verification, and finding the financial warranty subject to forfeiture, or failure to submit the 2016 annual map, and for failure to pay the civil penalty of $323 assessed for violation MV 2017026. The last inspection performed by DRMS was on September 2nd, 2014 by formal EPS Tyler O'Donnell. As of today, the operator has failed to submit the 2016 annual map and has failed to pay the civil penalty of $323 assessed for violation MV 2017026. The division's recommendation is to affirm
the division's findings of violation MV 2017-026, revoke permit M 1989-024 pursuant to CRS 34-32.5-124, parent 6, and find the financial warranty subject to forfeiture pursuant to CRS 34-32.5-118, and to issue a cease and desist order from all mining-related activities for this permit. Have any questions? Here's my presentation. Do you have any questions this time?
Any questions? Any comments? No?
I recommend approval of staff recommendations on M-189-024.
Thank you. Is there a second? Mr. Randall, second. It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Hearing none, motion passed. Thank you very much. Okay. This is agenda item 14. Rio Blanco County. What is this? Oh, that was taken off, yeah. 15, yeah.
This is item
16?
No, 15.
What I thought. Okay.
Okay. This is a formal hearing for the Deleggy Pit, number 1, permit number M 2005-023. This matter is being brought before the board for consideration of violation, civil penalty, cease and desist, corrective actions, permit revocation, and finding the financial warranty subject to forfeiture for failure to pay 2015 and 2016's annual fees, failure to submit 2015 and 2016's annual reports and maps, and for failure to pay the assessed civil penalty of $323 for violation MV 2017007. The site is located in Logan County, half a mile southwest of Padrone, Colorado, at an elevation of 4,510 feet. It is a 110C. Permitted acres is 9.99, and the commodity is sand and gravel. The chronology is located in the presentation packets I passed out to each of you, which lists all correspondence relating to this matter. The division does hold a certificate of deposit bond in the amount of $12,500 for this site, and it is adequate. I'm sorry, it is not adequate. I apologize. Not an adequate bond. The last inspection was performed by DRMS on December 15, 2016 by EPS Jared Ebert. And as of today, the operator has failed to pay 2015 and 2016's annual fees, has failed to submit 2015 and 2016's annual reports and maps, and has failed to pay the assessed civil penalty of $323 for violation MV 2017007. It is the division's recommendation to affirm the division's findings of violation MV 2017-007, revoke permit 2005023 pursuant to CRS 34-32.5-124, parent 6, to find a financial warranty subject to forfeiture pursuant to CRS 34-32.5-118, and to issue a cease and desist order from all mining-related activities for this permit. And that concludes the presentation for this matter. Do you have any questions?
Did this operator testify before the board?
I don't believe so. You know, there?
We
No,
didn't.
they weren't here last year.
Sorry, just to be sure, what is the violation number for this site? Because you have two violation numbers.
For this particular violation is MV 2017007.
Okay. Attempting to move along here.
I move that we accept staff recommendation for file number M-2005-023.
Second.
Been moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Motion passes.
In regards to the hearing, the Prius exploration project, we have some documents that we still need to move forward with this one. So we would like to move this to the August MLRB, the NOI P 2014-022, the Prius exploration project. That would be okay with you?
Request to continue to the August.
Do I need a motion on that?
Do, yeah.
Would somebody give me a motion on that?
I move to move it to the August meeting.
There you go. Thank you. Is there a second? Moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed, same
Nice,
sign.
nice strong motion, Lauren, for your first one.
Good. Yeah. Okay.
Hold on just a second, Mr. Chair.
So Rook's right.
Oh, we went past it? Oh, just reading it.
That was the rest of it.
Excuse me, excuse me.
You covered a lot of ground while I was in the restroom.
Sorry?
I thought you covered a lot of ground while I was in the restroom.
Can I go ahead and ask for public?
No, we need to, sorry.
No, he's already announced this case. So it's
I'm not finding our info. Oh, here we got it. Here we go. We're okay. We're good.
We got you.
Thanks.
Apologize for that, you all.
We're fine. We're fine.
This is a formal public hearing for the WJ oil field pit, permit number M1992-065. This matter is being brought before the board for consideration of violation, civil penalty, cease and desist, corrective actions, permit revocation, and finding the financial warranty subject to forfeiture for failure to pay the 2016 annual fee, for failure to submit the 2016 annual report and 2016 annual map, and for failure to pay the civil penalty of $323 assessed for violation MV 2017024. This is a 110. In regards to the permit type, it is 110C. The permitted acres is 9.90. The commodity is gravel and it's located in Rio Blanco County. It's approximately 4 miles west of Rangeley at 5,300 feet in regards to elevation. The chronology is located in the presentation package I passed out to each of you, which lists correspondence relating to this matter. The division does hold a corporate security bond in the amount of $8,400 for this site, and it is adequate. The last inspection was performed on May 2nd, 2017 by EPS Travis Marshall. As of today, the operator has failed to pay the 2016 annual fee, has failed to submit the 2016 annual report, has failed to submit the 2016 annual map, and has failed to pay the civil penalty of $323 assessed for violation MV 2017024. It is the division's recommendation to affirm the findings of violation MV 2017024, revoke permit M 1992-065 pursuant to CRS 34-32.5-124 parent 6, and to find a financial warranty subject to forfeiture pursuant to CRS 34-32.5-118, and to issue a cease and desist order ending all permitting actions for this operation. And that concludes the presentation for this matter. Do you have any questions at this time?
I move approval of staff recommendation on M-1992-065.
Thank you. Move second.
Second.
Moving second. All those in favor signify by saying aye.
Aye.
Those opposed, same sign. Motion passes.
Thank you.
Thank you. Is there anyone here today that wants to have any public comment in front of this board? Apparently not, so I need a motion to take the board into executive session.
You do it. John gives it to you.
Boom.
I'll let him go.
It is page 344. So I've asked Cammy to go ahead and put the motions right into the electronic packet, so it's just right in there.
344, I know. It's not here. Would that be different than mine? Oh. I move that the board enter into executive session for the purpose of discussing matters required to be kept confidential pursuant to Colorado Revised Statutes, Section 24-6
You can do one motion for all three
All three,
department numbers. Whoever
I know
wants
you
to make
guys are
it.
getting tired, so if we can
Yeah,
combine those, that'd be nice.
I move that we good. Okay, I move that we accept staff recommendation for NOI file numbers P-1981-045 and P-1995-005 and P-2001-021.
Second.
Any discussion? Hearing none. All those in favor signify by saying aye.
Aye.
All those opposed, same sign. Hearing none. Motion passes. We need to go back in now.
We do. Do you want to break before we do that? We have a. Do you want to break before we do that? I'm fine. I'm just asking.
Anybody want a 5-minute break or anything?
We just
back
have
in
executive session. Jeff and I have a number of cases to talk to you about.
You want to go now or you want a 5-minute break?
I'm good. We're going on.
Okay.
Good.
Your motion is in your packet, page 408.
Yeah. Let me see read it here.
Absolutely. And when you read, that's why I underlined this. So read this and then the bullets.
Okay. I move the board enter into executive session for the purpose of discussing with counsel disputes that are the subject of pending and or imminent court action, discussing specific claims or grievances, receiving legal advice on specific legal questions, and discussing matters required to be kept confidential pursuant to Colorado Revised Statutes, Section 24-6-402, paren 3, paren A, paren 2. And then I would refer to Rudolph Fontenary et al. Versus Colorado Mineland Reclamation Board, Colorado Division, Reclamation, Mining and Safety, Snowcap Coal and Jason Carey, 207 CV 30391. And then we have Jason Euchre versus MLRB and the Division of Reclamation, Mining and Safety, 2014 CV 546, Transit Mix Concrete versus MLRB et al., 2017 CV 30217, and Pride of the West LLC et al. Versus MLRB and the Division of Reclamation, Mining and Safety, and Colorado Goldfields, 2017 CV 30268. Is there a second?
Second.
Been moved and seconded. We'll now stand in executive session.
You get to call for a vote.
Oh, I do?
Yep.
All those in favor say aye. Aye. All those opposed, no. Hearing none. We're in
Right.
executive session.
Okay, I'll start with Jason Euchre. Quick update on that one. The Supreme Court denied Mr. Euchre cert on his appeal, so unless he finds some federal constitutional issue to raise it to the federal bench, we are finished with Mr. Euchre. I don't expect that to happen, but I'm not going to say never. Transit mix, and then I'm going to turn it over to the gentleman at the table. In the transit mix concrete matter, we have a deadline of August 1st to file the administrative record. Transit mix has designated administrative record, a very broad one. Scott and I are working on it. Scott has entered his appearance in the case with the expectation that I will be coming off of the case whenever you all move to a new attorney. That new attorney will be added, but I wanted some overlap so there'd be some experience in the case before the new person took over. So Scott and I are fighting this battle together, and Scott's been dealing with Transit Mix's attorneys. I understand he's gotten them to stipulate that their designation of record is excessive and broad beyond what the APA requires. So we will be providing a record in compliance with the stipulation. That is where we are. Yeah, we've been working on it. It's a rather large, as you might have guessed, it's a rather large record. So we'll be working on that. And if we don't get it done by the 1st, we'll just file something with the court that tells them why we're not filing it on the 1st and when we will file it. Shouldn't be a problem. Anything to add on that one, Scott? No. Okay. And I'll turn it over to Jeff and Scott for their other two cases.
For the snowcap coal matter, some of you are here for Mr. Fontenary's case against the coal program. He has filed in Mason County District Court. We filed our answer in response to their complaint on July 13th. We are working on compiling the administrative record. Once the administrative record is filed, the opening brief will be due 42 days after that record is compiled. Then we will have 35 days after that to file an answer brief. So it's a slow slog with that one too. But that